court for its part also does not believe that there's conflict either in the Michigan court rules or the case cited there under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus de jure bond stands.
Good morning, Your Honor. Raymond Cook for the People.
Good morning, Your Honor. Assistant Public Defendant Nick Bukovich on behalf of Mr. Bond Sanders, who is now approaching.
Your name, sir? Your Bond Sanders.
Your Honor, this time the people are unable.
The defense moves to dismiss, Your Honor.
For being unable to proceed, this case is dismissed on the prosecutor's motion. All right.
No problem. Well, we're supposed to be able to share the just emergency, so I'm covering cases.
What was mine?
Miss Kearney and Lauren. Yeah. I remember.
All right, you're all set.
Thank you, Your Honor.
Court does call the case of the People versus Kelvin Jones.
Morning, Your Honor. Sign language interpreter.
Yes. Yes. She can come up this way. She's facing him. May I have them sworn?
Raise your right hand. Do you solemnly swear affirm that you will interpret accurately, completely, impartially, using your best skill and judgment, and to translate from spoken English into American Sign Language, and from American Sign Language into spoken English in the matter now before the court, so help you God?
Yes, I do. Yes, I do.
Ms. Lundy, Ms. Rose?
Yes.
Thank you.
Good morning, Your Honor. Raymond Cook for the People.
Good morning. Good morning, Judge. Christopher Quinn appearing on behalf of Mr. Jones, who's present.
Your Honor, the people are unable to proceed.
Defense would move for dismissal.
People being unable to proceed, this case is dismissed without prejudice.
Thank you.
Thank you.
Thank you, Your Honor. Thanks.
Court does call the case of the People versus Grant Touche.
Good morning, Your Honor. Raymond Cook for the People. This is a PD case. I can go and grab them again.
Bukovich. Do I have any more? Sir, state your name.
Grant Matthew Duche.
Maybe I'll tie them to the table.
I think it's a pre. This for a few minutes.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Doucet.
It's already stated his name.
Thank you, Your Honor.
All right.
Proceed.
At this time, Your Honor, the defense will move to dismiss.
People being unable to proceed, this case is dismissed without prejudice. Thank you. Thank you, Miss.
Thank you, Your Honor.
Well,
This is your phone.
got it. Court does call the case People versus Brianna Force.
Your Honor. Raymond Cook for the People. She was inside room.
It's okay.
Now Bukovich is here.
I can walk out.
Well, I might want you to, but not right this second.
Oh.
Judge, should I put my name on the record?
Yes, please. I've called the case.
Sorry if it was at that point. Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Miss Brianna Force. She's not here yet. I know she was taking transportation from Detroit to Ann Arbor.
Here.
In the process of doing that, or?
I didn't get to connect with her. I just came off of a Zoom for a court. But we spoke earlier this week in detail.
Your Honor, this is an incident where previously this case had been set, neither the victims nor the defendant failed to appear. Again, the victim did say that people are unable to proceed. I would leave it to the court's discretion whether the court wants to issue a bench warrant or dismiss on motion from defense due to the people being unable to proceed.
Your Honor, I would try, I would ask that you not issue a bench warrant because I will try and connect with her now.
I'll tell you what, is there going to be any objection to me proceeding on defendant's motion to dismiss in absentia of the defendant?
No objection from the people, Your Honor.
Thank you, Judge.
If this case is, people being unable to proceed, this case is dismissed
Thank you.
on defendant's motion. Really did think I was going to issue a bench. Never mind, don't answer. All right. Don't answer because you're going to hurt my feelings. Court does call the case People versus Anthony Johnson.
Morning, Your Honor. Raymond Cook to the people.
And good morning, Your Honor. Edward Dukas, on behalf of Anthony Johnson, I'm standing in for the attorney of record, Hugo Mack.
Anthony Johnson.
Thank you.
Your Honor, the people are unable to proceed.
And I would move to dismiss.
People being unable to proceed, this case is dismissed on the defendant's motion without prejudice.
Thank you. Thank you, Your Honor.
Court calls case of the People versus Mohammed Mufid.
Morning, Your Honor. Raymond Cook to the people.
David I. Goldstein appearing on behalf of the defendant.
Mohammed Mufid.
Your Honor, the people are unable to.
Move to dismiss, Your Honor.
For being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you. Court calls the case People. Well, court calls the case People versus Jason Pope.
Morning, Your Honor. Raymond Cook to the people.
And good morning, Your Honor. Edward Dukas on behalf of Jason Pope, who is approaching.
How you doing, Honor? Jason Travis Pope. Thank you. I'm doing well.
You are unable to
Dismiss, Your Honor.
For being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
Court calls case People versus Kyle Sawowski.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. Edward Dukas on behalf of the defendant.
Sawowski.
Your Honor, I don't have any problem. People are unable to proceed.
I would move to dismiss and run out of here.
I almost don't want to grant it. People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
Court calls case People versus Chance Baylor.
Morning, Your Honor. Raymond Cook for the people.
Yeah, Assistant Public Defendant Nicholas Bukovich on behalf of Chance Baylor, who is now approaching.
Your name, sir?
Chance Baylor.
Thank you.
Your Honor, the people are unable to proceed.
The defense moves to dismiss, Your Honor.
For being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
So,
That's it.
after this committee correction is it.
Court calls case People versus Nathaniel Flanagan.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Flanagan, Your Honor. Good morning.
Your name?
Good morning, Your Honor. Nathaniel Flanagan.
People are unable to proceed.
Move to dismiss the charges.
For being unable to proceed, this case is dismissed on the defendant's motion. That's without prejudice.
Thank you, Your Honor. Good luck.
Court calls the case People versus Angela Hayes.
For the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Hayes.
Here.
Does not appear so, Your Honor.
Your Honor, okay, or unable to proceed.
And I do know Ms. Attorney did have contact with Ms. Hayes this week, so I would be asking for the court's consideration of a motion to dismiss.
People have no objection to proceeding in absentia.
Correct.
People being unable to proceed, case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
Court does call the case of the People versus Anthony Rabago.
Morning, Your Honor, reading for the people.
And Assistant Public Defendant Nick Bukovich on behalf of Mr. Rabago, who is now approaching. Mr. Rabago, could you please state your name for the record?
Anthony Rabago.
Thank you.
Your Honor, people are able to proceed. It's my understanding based off of communication with Ms. Perry this morning, it's going to be a joint request for an adjournment. This was reading Ms. Perry's case and she wants the ability to handle it and resolve it herself.
Is that a correct? That's a,
That is the correct representation of the emails with Ms. Penny. I was CC'd on that email, Your Honor.
I'll adjourn this to the jury final settlement conference to October 16th, 2026, 9 a.m. The jury selection following that, if necessary, will be October 19th, 2026 at 8:30. Both of those proceedings are in person. Bond will continue. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Tyree Russell.
Morning, Your Honor, Raymond Cook for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Tyree Russell, who is now approaching.
Really?
They look comfy, Your Honor.
But unable to.
And the defense makes a motion to dismiss, Your Honor.
Is that all you had? Don't answer. Don't answer. People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Look at him.
Any more of your clients look like they're going to a picnic?
I hope not.
You don't know. All right.
I haven't looked at everyone's pants, Your Honor.
Court calls the case Hugo versus Jackson Sertivant.
Morning, Your Honor, Raymond Cook for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mrs. Sturdivant, who should be approaching.
Thank you.
Your Honor, I received some additional information from Ms. Perry yesterday that leads me to believe that prosecution is no longer in public interest. I would move to dismiss.
No objection.
No objection, Your Honor.
Case is dismissed on the prosecutor's motion without prejudice. All right. Thank you, sir. Thank you. Court calls case People versus Lakrita Thompson.
People.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Thompson.
People are unable to proceed would have no objection to have this case heard.
And I do know Ms. Kearney did have contact with Ms. Thompson earlier this. I would be requesting the dismissal based upon the prosecution's lack of ability to proceed.
Being unable to proceed, this case is dismissed. Court calls case People versus Basola Lambo.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Lambo, who is now approaching.
Hello,
Hello, your name?
Basola Lambo.
Thank you.
We do have an agreement, Your Honor,
All right.
and count two of the whole parking.
Okay.
And the responsibility that added count two, we would accept it and dismiss original charge.
Got a quick statement?
Yes, Your Honor.
Hey, Ms. Lombo, do you admit responsibility to the fact that on or about good way to start out the new year, January 1st, 2026, location of Torrey Avenue, Pittsfield Township, Washington County, State of Michigan, that you double parked the motor vehicle?
Yes, Your Honor.
All right, court will accept that. Admission count two, count one is yes. Fines and cost of $180. When can you get that paid?
I can pay it today. In full.
I like that client.
This is a wonderful answer.
It was the best answer in the
It's great hands.
Wow. Okay. All right.
I need everything going for me today.
Pay that out at the counter, man. All right. Have a great weekend. So the record's clear. Everybody has had pants thus far. Court calls the case versus Jalen Washington.
Your Honor, Raymond Cook for the people.
Ron, trying to bring on behalf of Mr. Washington.
How you doing?
I'm doing great. How you doing?
All right.
All right. State your name.
In Washington.
All right. I have before me a plea form that indicates that the defendant will be pleading, it looks like, to the stated count two. Hang on a second. Well, let me make sure. I have as the set count one of operating while intoxicated, count two of carrying a concealed weapon while it's cut off. While under the influence. I see what it is. Okay, I read that wrong. So he's going to be pleading to the carrying under the influence, the 93-day offense, which is stated count two, and then also an added count three of operating while visibly impaired. He'll be pleading guilty to both of those counts. The second one being also a 93-day misdemeanor. In exchange for that, count one would be dismissed. There's also a sentence agreement to prosecutor's deferred sentence under count two. That's the court's full understanding of the agreement.
That's correct, Your Honor. Just for some additional clarity, the stated count two of carrying while under the influence not be added second count. I think I really cleared down more. I just want to make sure.
Yeah, on the form, and that was my mistake. On the form, it is carrying under the influence as the stated count two that he would be pleading to, and an added count three of operating while visibly impaired.
That is all correct.
Yes, Your Honor, that's
Correct. May I have him sworn?
You solemnly swear in the front of the testimony you're about to give today. It's the truth, the whole truth, and nothing but the truth. So, yes. State your first and last name for the record.
Jalen Washington.
All right. Sir, it is this court's understanding that you're going to plead guilty to two misdemeanor charges. Is that your understanding?
Yes.
The first is the stated count two of carrying a weapon while under the influence. That's a misdemeanor punishable by up to 93 days in jail, $100 fine plus court cost, and mandatory forfeiture of the weapon or device. You understand that? And also to the charge, an added count of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days jail, a $300 fine plus court costs. Court could order any rehabilitative services or community service the court deems necessary. The court could also order your people immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir? Understanding all of that, you still wish to plead guilty?
Yes.
To the charge of carrying a concealed weapon under the influence or carrying a weapon under the influence, how do you plead?
T.
To the charge of operating while visibly impaired, how do you plead?
T.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily
Yes.
of your own free will. And because you believe that you're guilty of these offenses?
Yes.
On the date of November 2nd, 2025, at the location of I-94 near Carpenter Road in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had 2 cups of Bacardi.
2 cups of Bacardi? Okay, were you stopped by the police or was there an accident?
I was stopped by the police
Why'd they stop you?
because I was swerving.
Swerving? All right, you're not challenging the right of the police to stop you in this case, are you?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital? Was there a blood draw? And what were the results of that? The results of that blood draw were a 0.111. Is that correct? All right. And you have any reason to dispute those results?
No.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
At the time that you were operating that motor vehicle, did you have a weapon in your possession?
Yes.
What'd you have?
CZ.
Pardon?
A CZ
Okay. And where was that located?
in my glove compartment.
Okay. You didn't have authority to carry it in that fashion, did you?
One more time.
You didn't have authority to carry that weapon in that fashion.
No.
All right. I think that does it. Sir, I do have to advise you that if between the time I accept your pleas and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea. Court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to counts 2 and 3. Count 1 is dismissed. Defendants referred to Von Swartz, well, actually, because of the other charge, referred to probation, Von Swartz for an alcohol screening and assessment, and the victim's impact panel. Sentencing in this matter will be September 9th, 2026, 9 a.m. As your invite indicates. Bond with its conditions.
Thank you, Your Honor.
You, sir, on your way out, stop down at the hallway there on the left at my probation department. Check in and get the process started. Okay. All right. Thank you, sir.
Thank
Have a good weekend. Court calls the cases of the people versus Devontae Smith.
People?
Carolyn Foster Tucker on behalf of Devontae Smith. You see,
Your name?
Devontae Smith.
we'd ask for a dismissal of both cases.
Okay. We have the violation. Sure. Sure. Oh, sure. Got it. I think we addressed those before. I'll do it this way. First thing I'll do is I'll cancel the bench warrants because bench warrants had been issued because you were in the exclusion zone again, young man, after I gave you the warning. Do you remember that?
Yes, I do.
It's a good thing they didn't get you before you got here today. I'll cancel the bench warrants. Case People being unable to proceed, this case is dismissed. Both cases are dismissed.
Thank you, Your Honor.
Without prejudice. Thank you.
There's any.
That's it.
And Gibson, I think we can call his suitcase of.
Jail actually needed a minute. Jail is not ready to restart.
Okay.
I believe we're also ready to call Kasham, Caleb Kasham. Also, Maria Don Mariah. She here. Okay.
Court does call the case, Peter versus Caleb Shaw.
Morning, Your Honor, agreement code for the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, I spoke to Mr. Kasham this morning. Apparently, he and his parents were the victims of an attack by some savage lettuce. His parents are in the hospital, and he also has the virus, although he is not in the hospital. And he said, given a day or two, he can get proof of that. But I just found this out about maybe 15 minutes ago. So and he has appeared every time up until now.
Yes.
So I'm going to ask if the court would consider an adjournment. I think the matter is going to be resolved. I don't think it's going to go to trial.
Having had firsthand experience with some particularly savage lettuce, I will leave to the courts to.
Wow, really? I threw all mine away, and that's
I just stopped going to taco.
a salad.
I just stopped going to Taco Bell. That's
Well, got lettuce. I'm not doing it. I've always thought lettuce was useless anyway. It takes more energy to chew it.
Listen, I was having a problem with Taco Bell long before this thing with the.
All right. I will adjourn, given those circumstances, jury final settlement conference to October 16th, 2026 at 9. Jury selection, if necessary, following that, October 19th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor. Thanks, Ray.
Tell your client, I hope he feels better.
Thank you, Jeff.
And
You're on.
I did something. Let's go someplace. Court calls the case People versus Mariah Denell.
Your Honor, agreement code for the people.
I'm only on a Christine Saxon for Mariah Donald. It's all right. It's okay. I'm used to it. Mariah Donald.
No, you're okay, man. You were just waiting to get up there to criticize me about something.
To criticize
You
you?
have to be that, wasn't it? Isn't that
Criticize you?
huh?
Criticize you about something? Would I do that?
Of course not.
People are unable to proceed.
Okay. I'm almost gonna not grant it, Saxon.
Defend,
But
to dismiss without prejudice.
people who being unable to, and its motion to dismiss, granted, that is without prejudice. Without me.
Thank you, Nana.
Court calls case People versus John Smith III.
Your Honor, agreement code for the people.
And Assistant Public Defendant Nicholas Buckovich on behalf of Mr. John Smith, who is now approaching.
Okay.
John Smith III, Your Honor.
Thank you.
Your Honor, people are unable to proceed.
Defense moves to dismiss, Your Honor.
For being unable to proceed, this case is that's without prejudice. Thank you. Have a good weekend.
Thank you. Okay.
Does Miss Saxon have something else or can she leave my court? But, no, yeah, look, I'm talking to my staff. Court calls the case People versus Devon Gibson, 2 cases.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Edward Dukes on behalf of the defendant. Standing in for the attorney of record.
Yes. You're standing in for Mr. Sachs.
Yes, Your Honor.
Your name, sir?
Edward Gibson.
I would move to dismiss.
And Blair, you have no objection to Mr. Durkis stepping in? Yes.
No, sir.
Okay. People being unable to proceed in either matter, these cases are dismissed without prejudice.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome, sir. What? That's it?
Oh,
Right. And also.
Goodbye, Miss Sackman. Have a good weekend. Court does call the case of the People versus Demond Bransford.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Trovia Star on behalf of Mr. Bransford. Mr. Bransford, state your name.
Demond Bransford.
I have before me a plea form that indicates that the defendant pleading as charged to the count of assault and battery, the 93-day offense. There is a sentence agreement to time served.
Correct, Your Honor. Some additional context. This was an assault that occurred at the jail. And it did a month or two in custody on this and some other matters. He's sentenced, I believe, out on 15th on the 18th
Correct.
of August for an attempt resisting and obstructing the 1-year misdemeanor out there. My understanding he's also on probation on circuit court already. I didn't want to be on 3 different courts probation, which is why people were willing to try to serve my costs.
And that is correct, Your Honor. The victim was the previous case that you just called.
Got it. Okay. I don't, given the circumstances, I don't think there's going to be, I'm certainly not going to have an objection, but he'll still have to go through the probation department to see what happens because it's a victim's rights case.
Yes, Your Honor. I did explain that to my client.
Okay. May I have him sworn?
Do you solemnly swear and affirm the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
State your name for the record.
Demond Bransford.
Thank you. Sir, it is this court's understanding that you're going to plead guilty to the charge of assault and or assault battery. Is that correct?
Yes.
That's a misdemeanor, punishable by up to 93 days of jail, $500 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty?
Yes.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on there.
Okay.
So yes.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Were you on probation at the time of this offense?
Yes.
All right. Just so that we're clear, is that one of the probations?
That would be
The circuit.
Circuit court probation. All right. I do have to advise you, sir, that your entry of a plea in this case could then be considered a violation of that probation. You understand that?
Yes.
As such, if it is considered a violation, that court could sentence you to the maximum allowable under those other charges. You understand that?
Yes.
Understanding that, you still wish to plead to this charge.
Yes.
Has anybody promised you anything? Wait,
No.
other than what's been stated? Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of March 24th, 2026, 2201 Hogback, the Washington County Jail. What'd you do involving a Devon Gibson that makes you think that you're guilty?
I assaulted him.
How did you assault?
Oh, I punched him.
Punched him?
Yeah.
All right. You didn't have his permission to do that, did you?
No.
And it wasn't an accident on your part?
No.
Intentionally, correct?
Yes.
Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
Not from defense, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant's referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be September 9th, 2026, 9 a.m. Bond in this case will continue. All right, thank you. Sir, stop down at the probation department on your way out there on the left, just so we can get the process started. Okay?
Okay. Thank you.
Okay, I watch on YouTube, all of you.
Look,
That'll work.
ma'am. Thank you so much for telling me that. I do appreciate that and all your kind words. All right. You do the same and have a blessed weekend.
Judge, can I get your autograph?
Yes, on the warrant I issue for you, you can have it. Thank you, Mr. Starr. Yeah, I told you I'm a nice person. Yeah. Despite all those things you said. Okay. Court does call the case, People versus Caitlin Davids.
Conrad Sword on Field Township.
In assistant public defendant Nicholas Buckovich on behalf of Ms. Davidson, who is now approaching. Can you please state your name for the record?
Caitlin Davidson.
Thank you.
And we do have an agreement.
Okay.
Get a big responsibility. How to go again. If you accept that admission and move to dismiss the original charge. Oh, excuse me, the original. So in case 0785, I'm gonna add count 2, etc. Go parking. If you accept that admission, I move to dismiss the original charge as well as dismissing case 0786.
Got it. Okay.
That is also understanding of the agreement, Your Honor.
Ma'am, do you admit responsibility? In fact, that on or about June 6, 2024, location of Gulfside Road, Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yeah, Your Honor.
The court will accept that admission in case ending in 0785. That's as to the count 2 in that case. Count 1 is dismissed as well as the case ending in 0786. Fines and costs $180. When can you pay that?
I paid today.
I know, that's 2 in a row.
Hey,
Amazing. And you take credit for that, right, Buckovich?
Of course.
All right. You get blamed for everything, so take credit.
Take whatever I can. I understand.
All right. Thank you, ma'am. Have a great week.
Thank you, you too.
Have a good day, Mr.
Just. No, I'm gonna take a break, but I don't know what, there's other people staring at me.
Ready on June. Yeah, what was the other one we discussed?
Usually Ryan.
And then did want to call Cleveland, see who plays out. So June, Bryant, and Cleveland.
Court does call the case, people versus Orita Bryant.
Morning, Your Honor, Raven Cook for the people.
And Assistant Public Defender Nicholas Buckovich on behalf of the client who is now approaching.
Your name?
Bryant.
Current people are unable to proceed.
Your Honor, the defense moves to dismiss.
Okay. Where's her? This is another one where we had that in. That must be it. Council approach.
Charges. You're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Mr. View?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on May the 24th of 2026 in Hamilton Township, Warren County, state of Ohio, that the defendant caused serious physical harm to Milana Cofield, a family or household member.
Anything on those facts, Mr. Kramer?
Not at this time, sir.
Mr. Hunter, did you hear those facts?
Sure.
Do you admit they are true?
Yes, Your Honor.
Do you understand the right you're giving up by entering a plea?
Yes, Your Honor.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you've been fully advised of your constitutional rights, which you waived and rejected here in open court. I also find that you have violated the terms of your supervision in the 25 CR 43065 case. I'm going to set this for sentencing. We're going to do a level 2 PSI, and we'll see everybody back here in about 6 weeks. Anything else we need to do today?
No, sir.
All right, that's all.
All right. Thank you.
So, case of the state of Ohio versus Brandy Becknell, case number 26 CR 43822. We're on the record for the purposes of executing a nollie, which the court will do at this time.
Record should reflect we had a bench conference in this case. There's a bench warrant currently outstanding. There's community corrections violation. I think you've had an opportunity to review that with your client. And ma'am, do you admit to the violations?
Yes.
Yes, we don't.
Okay.
I'll sentence the defendant to $250 for the violations. You can pay that today. Is that correct?
Yes, sir.
Pay that today. And then people are unable to proceed and you agree to dismiss.
Yes, that's correct, Your Honor.
So upon the payment of the $250, the case will be dismissed.
I've had them. This is the clerks.
All right. Thank you.
Thank you.
No problem. Once she pays the $250, the bed, even.
Can I see that? Say what?
He was asking about the bench.
Oh, you still want it? Oh, okay. I'm just checking. If you still want it, I'll let it hang out there. I did not say that, so I should say that. Thank you for reminding me. I'll cancel the bench one. You're welcome. Court calls case people versus Anaya Cleveland.
Your Honor, Raymond Cook for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Cleveland, who is now approaching.
Your name?
Anaya Cleveland.
Thank you.
Your Honor, this is the day and time set for final settlement conference. The victim on this case reached out to our office yesterday, indicating that she would be unable to be present today because she could not afford to take time off of work. She has been communicating with our office and reached out to us. If the court would excuse her appearance, that people would be able to proceed. But I do understand the court does have a requirement that victims be present in person. Nevertheless, given that.
But they've been in contact with your office.
Yes, they called us yesterday. I can see how much contact we've had before yesterday. We just want a second. Let me just double check that my victim advocate correctly. So it appears that yesterday was the first time that actually she did reach out.
But she did reach out and could explain it. Okay.
Your Honor, today is the time of day for final settlement conference. As APA clerk indicated, typically it is required that the complaining witness be here. This contact was not made until yesterday. I do understand that they do have time to make contact. However, I would expect that the prosecutor's office probably did reach out multiple times and earlier. So I would be asking, based upon the complaining witness's failure to appear today, for this case to be dismissed.
I'm a bit reluctant to do that in this matter. Counsel approach.
What's about next?
Okay, let's start off here with Crystal Dan Iovan. Crystal Vaughn, where's Crystal Vaughn? Come back there. Oh, she's in the back. All right, who's on this one? Yeah.
guess I'll play part of it too. You
know, she's been acting irregular.
Yes.
Or maybe it's regular. But the last thing I have about competency was November of last year where she was deemed competent.
Yes, Your Honor, she lied at that time. Dr. Kaplan had previously diagnosed her with the dissociative identity disorder. And you can ask anybody at the jail. You can ask the bailiffs here. You can ask all the guards over there at the jail. She is totally competent.
She's what?
She is incompetent.
Okay. Ma'am, you're being rude. Don't speak over us. Thank you. Thank you. Go ahead. Don't be, please, be polite and follow the rules. Thank you. Go ahead, please.
She has a.
This is a kangaroo.
You're interrupting again. That's rude. Don't do that. Go ahead, Bruce.
She has 5 prior hospitalizations, Your Honor.
What do you want to do to them?
We want to, I think we're in a position.
Should we get an update from Edgar Pond?
It's going to agree.
Should we get an update from Edgar Pond? Because the last thing we have here is a competency.
Collect the blood.
Well,
that's rude.
I think we're, because of all the bailiffs, the guards, the way she is, I think under the statute, parties can agree that she is, that she needs to.
I don't get
Doesn't agitate her.
I'm gonna get Dr. Rapon just to follow them. We're doctors of jurisprudence, not doctors of medicine. Let him do it and give guidance on what needs to be done. But it's obvious she needs some assistance and help, and she's acting irregular again as she did before. But the last thing we have is a competency. Let's get Dr. Rapon in there, and he'll come in as soon as possible, please, and get an analysis, which I'm sure will be what we all believe. And then he can guide us on what is in the best interest.
But also the investigation that I have, and we have the jail records to show.
Okay, I've seen that. I agree with you, but it's last determined. Let's get an incompetency evaluation result from the doctor as soon as possible. Thank you. And we'll see you later, ma'am. Thank you. Good luck to you. Bye-bye. Elisa Adams.
I can hear it, Judge.
It's a hearing on what?
It's a motion to revoke probation. Let me get it.
Chat. Brought my Kleenex, moms. That's good luck and hater. I think it's gonna be a good day.
Yes, sir.
20-33873 is called the state of Texas versus Elisa Adams. Are you Miss Adams? And you're here with Mr. Adams. Are y'all related by any chance? No.
No, sir.
Making that clear for the record. She's shaking her head.
That's a vigorous no from
record. That's a vigorous head shake.
No, sir. No, sir.
Well, Adams is not an unpopular name, as and Langston Adams is here, so we're fine.
Thank you.
Does the defendant waive a formal reading of this motion to revoke unadjudicated probation filed on June 5th of this year? Can we proceed in summary?
Yes, sir.
Is that what we want to do here? Go through this, or we're going to go through it? She's going to make pleas to admissions or denials and see where we go from there.
And Your Honor, the state has witnesses here. We're prepared to go forward with With a hearing if necessary, Judge. We've attempted to resolve this by plea agreement and it has been unsuccessful.
Right, because it stays off for 5 years, and I don't believe, considering that she's been on probation, for unadjudicated probation, Judge, and this, she put in probation in 2022. This is now 2026. She's about to complete the probation. We just specifically saying that jail is not warranted in this case. So we're prepared to have a hearing. So we'll have the hearing to be ready, Judge. And what else witnesses the states have, I'm ready to cross-examine them. So let's have the hearing. If the state won't have it, you can have it.
You about through? All right. So let me get this straight. You want to hear it?
I think that's what you said, Judge.
Yes.
All right, let's find out where we are on all of this, okay? Raise your right hand, ma'am. Do you solemnly swear or affirm that the testimony that you are going to give today, if you give testimony, shall be the truth, the whole truth, and nothing but the truth? So help you God. Lord, you have to speak out so she can. Yeah. Okay, thank you. Can we proceed, Ms. Sutton?
Yes.
She waives a formal reading of this motion. This motion states that on April 5th, 2022, in this criminal district court of Jefferson County, Texas, you were placed on 5 years deferred or unadjudicated probation for the second-degree felony of aggravated assault causing serious bodily injury. Apparently with the use of a deadly weapon, a firearm, by striking somebody in the head with a firearm. Is all of that true?
Yes.
Okay, you're soft spoken. Okay.
I got it.
Allegation 1 states you committed the offense of evading arrest or detention on or about July 24th of last year, a year ago. Why did this take so long? In Jefferson County, Texas. This is a violation of condition 1 of your deferred or unadjudicated probation order, which states don't commit a crime. Is this allegation true or untrue? True or
not true?
It's untrue. 2, you committed the offense of assault, a Class C misdemeanor, on or about July 24th, same day, 2025, in violation of condition 1 of your probation order, which states don't commit another crime. Is that true or untrue?
Not true.
3, you it says, I'm going to skip that, failed to avoid injurious or vicious habits as evidenced by your arrest for a Class C misdemeanor in violation of condition 2 of your deferred or unadjudicated probation. And really, since, I wrote the article on presumption of innocence, and that she's presumed innocent just because she was arrested and doesn't infer guilt. All right. 4, failed to write a report to the probation office on or about May 26th of this year, which was a violation of condition 1 of your probation order, which is to report regularly. Did you fail to report on that day?
That's not true.
Okay, I'm anxious to hear that because the probation office seldom makes mistakes on that. 5, you failed to immediately report to the probation office your arrest on or about May 24th of 2025, which you must immediately report. Is that true or untrue?
That's untrue.
6. This one's interesting. Failed to dress appropriately and conduct yourself in a courteous and professional manner at all times when interacting with court officers and staff, probation officers and staff, law enforcement officers and attorneys as ordered by the court. You reported to the probation office on May 28th, 2026, dressed in inappropriate attire, and became argumentative when addressed by the probation office, prompting you to attempt to audio record the office visit using your cellular phone. And this is in violation of condition 14 of your deferred or unadjudicated probation order, which states, dress appropriately and conduct yourself in a professional and courteous manner when interacting with court officers, staff, and probation officers and others. Is that true or untrue?
It's untrue.
Yeah, I'm anxious to hear this one because I don't put up with rudeness. 7, and this probation office has the most successful rate of probationers in all of Texas. So they do a great job on pulling people across the finish line in success. All right, 7 states you failed to provide verification of performing community service hours as required. Is that true or untrue?
That's untrue.
All right, and then.
Your Honor, state would have been in allegation number 8.
Here's what I want to do. We're going to have a hearing on this, right?
Yes, sir.
I've got some other things I need to take up that can be done so that we can focus on just the hearings. If you would be so kind to work with me on that, Langston. I know how you are about, you've got a lot of things too, and you're an efficient guy, but if we can, I want to focus on the cases that we have hearings over and get the other ones out of the way so we can deal with those, okay? And that was, can you go to another court or something?
Yeah, that's not just what I noticed is that she had 2 witnesses on my.
Yeah, well, we're going to get to them as soon as possible, though. Okay, thank you.
All right, this house then.
What about Jasmine Dudley?
She's here, and that's a hearing as well. She is here, right here. That's Miss Dudley. All right, let me get her stuff.
Okay, if it's going to be a hearing too?
Judge, if my witnesses are here, it will be a hearing. I'd ask that both of their names be called by the bailiff, please.
Okay, what are they?
That would be Takesha Scott.
Takesha Scott? Takesha Scott, no answer in the courtroom. I asked the bailiff to call into the hall for Takesha Scott, please. What's the other one?
Varley, Officer N. Varley.
Officer Varley?
Yes, sir.
Law Enforcement Officer Varley? I don't hear. People are coming in.
No response.
No response. And can you call into the hall for Officer Varley? Varley.
Varley. No response.
No response, police, to the officers call in this courtroom. No response to their names, and we'll wait.
Your Honor, the state will be filing a dismissal of the motion to vote based on the non-cooperation by the complainants.
Thank you, Tom.
No, yeah.
Thank them.
You too.
I want to object to that.
No, I won't.
Okay, yeah, I didn't think you would. He's going to file it. I'll sign it. All right.
So you can tell our witnesses they can come back. We had, Judge,
You're still on probation.
Right. And we had a mom and CPS here.
Wow. So you just don't make a promise. You got to
No, I promise I will.
walk the walk. It's not talk the talk. Okay. Because you're capable. That's what's frustrating. I know you can do this.
I can.
When you're across, do it. Yeah, make us proud.
Yes, sir.
All right.
Judge, I know that they want to dismiss this one, but on my first one, the 2 witnesses that I really wanted to have are not here on this in Middleton. If I can just have one reset on that, unless you just got it over there.
Judge, I would be opposed to the mistake. I got witnesses here. I have an officer who made the time to be here, Judge. State's ready to go.
So this was she is probably on this right here. This lady doesn't watch this. It's already. I'm sorry, Jasmine. That's Jasmine. So, right, he's on this business also. The one I was asking, I can listen to 2 witnesses on this. I can do section. Sorry. I know what I'm sorry about that. I always think I ask. He said, well, I can be right down here. I know they apply these things. I also ask just ignoring this thing was so for because it's one of the things it's alleged he's gonna come police officer and so they started like she's here, right? She's still people want to sit in our time. So here's what I really want to do that time. Let's not burn daylight. Will go into it because I don't know this is on because I don't know part of this is less than these as if I'm going to get when I come back. That's okay. That's how police proceed. He needs a witness.
You have to do so. You don't get sense of myself. My stomach's because I'm here. I'm about to give you these weeks, but we'll pick up where we very often to put the other. But we're not going to do it right now. We'll pull that off and we'll pick up that hearing later on.
All right. Thank you, Judge. You free to go.
James Bacon, what are we going to do on Jay Nelson?
Your Honor, he's gonna plead to the motion, but I would request that sentencing be put off because I have a bunch of information to supply to the court.
What state say? Is that okay with you? How long were you talking about? Okay, Jay Nelson, where are you?
He's in custody.
Let's get him out.
Also, I filed it at your convenience. If you look at it, 7 on. He has a job at the front.
How much time are you asking for?
30 minutes.
Yeah. And we'll do it in 2 weeks.
You can try.
Come on up, sir. We call 22-39759. The state of Texas versus J. Brian Nilsson. Is that you?
Yes, sir.
You're here with Mr. Macon, your attorney and the state's attorney. There's a motion to revoke unadjudicated probation that was filed June 17th, about a month and a half ago. And does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes, sir.
And raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
The lawyer knows. In summary, this motion states that on February 5th, 2024, in this criminal district court of Jefferson County, Texas, you were placed on deferred or unadjudicated probation for 10 years for the second degree felony of burglary of a habitation. Is all of that true or untrue?
True.
Allegation 1 in this motion to revoke probation states you failed to report to the probation office on or about April 23rd, April 30th, May 14th, 2026, which is a violation of condition 4 of your deferred or unadjudicated probation order, which states to report regularly. Is that allegation true or untrue?
True.
Are you pleading true voluntarily and because it is true as it is alleged?
Sir.
You understand that a voluntarily and knowingly made plea true to one or more violations of probation, that's enough to grant a motion to revoke probation. In your case, your probation could be revoked. You can be found guilty and sentenced to no less than 2 nor more than 20 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
Yes.
Is that your final thought? You were looking over James for help there. Okay, this is your decision after consulting with him, correct?
Yes, sir.
That's what you're facing. All right.
Yes, sir.
I find you understand and appreciate the consequences of pleading true. And finally, allegation 2 states you failed to submit to alcohol and or drug screening on or about April 23rd, April 2026, April 21st, 2026. Well, that wasn't chronological. May 4th of 2026, May 5th of 2026, all at the direction of the probation office, and you failed or refused to submit to alcohol and or drug screening as required in your probation order number 26, which states, or 25 rather, which states submit to alcohol and or drug screening at the direction of the probation office. Is that allegation true or untrue?
Yes, sir.
Are you pleading true to that voluntarily and because it is true as it is alleged? Yes, true. And again, as before, we understand a plea of truth voluntarily and knowingly made of 1 or more violations of probation. That's all it takes to grant a motion to revoke probation like this. Your probation can be revoked. I can find you guilty beyond a reasonable doubt of this underlying charge of burglary of a habitation, and you can be sentenced to the full larger punishment, no less than 2, no more than 20 years confinement in prison. Knowing all of that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Now, what do we do?
Your Honor, I'm asking for 2 weeks before sentencing. I have a lot of information to supply to you that mitigate many of these allegations and on behalf of Mr. Nelson.
All right. Well, I'm going to give him a fair opportunity to prepare, but we'll reset this, come back in 2 weeks and pick up this hearing where we left off. Do you understand? Okay. Then. Right, sir? Yes, sir. Good. Okay. Thank you.
Thank you, Your Honor.
Yes, sir. The Marcus Roy. Ogden.
You want an update report?
Well, I'm not sure it's yours. It's getting there.
Every day is a good day. Yeah.
Just got to try lots of chocolates, buddy. You just don't know what you're going to get.
Yeah, I think it's.
I
said next week, I thought my birthday playing.
I have one place on DeMarcus, right?
Yes.
So what are we doing? This is announcement.
Yes, Your Honor, Mr. Roy is in custody in the Hardin County. This is a new prosecutor to the case.
What is that?
Mr. Cole, he took this case from the previous prosecutor.
Did he do that with her?
I don't think he did it with him. I think it happened. But anyway, since that has happened, I've not had an opportunity to really review the case with him, and I talked to him this morning. I'd like to have a reset. Just good. That's good.
That was good.
That's good.
You want to do what today?
I'd like to reset it in a couple of weeks.
What do you say?
Because I have to.
No objection, Judge.
Is that good? All right.
Yes.
And your request is granted.
Thank you, Your Honor.
Thank you, sir.
Very welcome. Hey, Bruce, on Nehemiah Armstead.
Yes, Your Honor. I'm waiting on discussing out of town to see. Every day.
Is that him? No. In 25 CR 389, the state of Texas versus Nehemiah Edward Armstead, the defendant. That you? Okay. You're here with your attorney and Miss. Well, I just don't see Kyle Gasper here today.
Why don't you?
Close by.
Is it home?
Is it? Are you going to take it over, or it was?
Yes, it's mine now.
Keisha.
It's mine.
You're not on this one.
Who is that, Judge?
It's Nehemiah.
It's mine.
It's yours.
It's mine now.
No.
It's officially been X'd out and my number is what's there now.
All right. So you're looking at up to 20 years in prison, as you understand. That's serious.
Yes.
And are you still on North Street? Okay. Mr. Smith is here representing. Hey, this thing's going on a year and a half old. It's just languishing. It was in April of last year. That's too old.
Yeah, I took it from another attorney.
Okay, well.
And I just have not received discovery of it.
Yeah, this morning I looked and saw the JIT and they didn't give it to you, and since it's mine now, you got it now.
I know you're busy. Can we quick on this to get caught up?
Right.
What are you shaking your head about? We can't do anything right now unless you want to plead guilty, and we don't have a jury, so don't be shaking your head. You ought to sit here if you're feeling frustrated, because we got a DWI back a decade ago, right? He is eligible for probation on that. Yes, looks like. Was the before you. Mr. Smith doesn't lollygag. He moves forward expediently. I mean, I can't say that whoever may have been representing you before. So. Reagan, no, she's good. He's public defender, but you hired him. Yes. Speak out. Okay. How much time do you need to be ready on this? Yeah, 4 weeks. Okay. All right. Get a reset. Thank you. And Crystal. Crystal Vaughn.
We already did that.
Yeah, that's right. Okay, Devontae Gilbert.
We need a moment, Judge. I've got to take a look at the paperwork.
Okay. Stand by. On Calvin Walker is Mr. Bill. Is your attorney here?
I'm here, Judge. If you can see me on the Zoom.
Oh, he's going to be on the phone?
I'm on the Zoom.
Oh, he's on Zoom.
Oh, we switch it over, Judge.
I'm here if y'all can hear me, Judge.
Yes, sir. We can hear you.
Earlier.
Oh, it's right here. It's just this.
Yeah.
Okay, I got the update from probation on Mr. Walker here dated August 3rd. And again, the defendant is out on appeal from his conviction and sentence in this case. And we have regular hearings while we are awaiting the appeals court decision on his conviction. And this report I've read, and let me ask Mr. Walker, how do you think you're doing?
I think I'm going to decide some on probation.
Yeah, okay. The total amount of restitution that you have paid up to this point is right at $18,000. It's shown, unless he's paid something since this report. No. All of that's going to the Beaumont Independent School District. Correct?
Yes.
And since March of this year, about $5,000 in restitution has been paid.
And then, Judge, we also have the properties signed over, and I know it hasn't been credited yet, but just keep that in mind.
Well, it's always in my mind. We're talking about the properties that are out at Pleasure Island.
I think there was two. I think there was another one, Judge.
Okay.
Mr. Walker, I'll handle it. Thank you.
What's the status on that? Has all of that been transferred legally?
We did that whatever day that was a number of months ago. The court had provided the deeds. We got them signed. We went down and filed them in the county clerk's office. So all that's done, but I don't know, other than transferring the title, I don't know what's happened there.
Why hasn't the title been transferred?
It is transferred. We did that day in court with the judge's help.
He's going to be given credit for the value of that, but
He hasn't received credit for it yet.
Okay, what are we waiting on for the credit worthiness?
I'm not sure. I am waiting for ADA Nealon to provide an update.
Okay, apparently something in the district attorney's office is moving through the dotting of the i's and crossing of the t's, but it's in the possession of the victims of this offense, and the Beaumont Independent School District will be able to use those properties as they deem appropriate. Oh, so it looks that as though you have been steady in the monthly payments, but I know when we started all of this, there was a lot of hope that because of your abilities, there'd be a lot of jobs, that you'd be handling. How are we doing on that?
Well, I've been applying, like y'all said, and nobody's really trying to hire me right now with a convicted felon on my record.
And Judge, I was going to mention, I think he's applying for 5 jobs, and forgive me, I think it's a week, might be a month. He's also doing the home shield, like the call out plumbing stuff whenever they call him. I think he's running out of places to apply. Do you want him to go back to places that he already applied? Is that what you suggest, or what are your thoughts on that?
Well, the more income he can get and pay to the victims, the better off it is for the victims and the interest of justice. But I can't go out and apply for him, but I rely on the probation office. Probation office is satisfied that Mr. Walker is vigorously applying for opportunities to get income so that income can turn around and be paid to the victims.
Yes.
Your probation office is satisfied. Just keep trying. But yeah, being a felon is going to close off doors of opportunity, but not all doors of opportunity. And you have convinced us that you have abilities that folks need, and they need things built. And you can you've already paid about $18,000, but once again, it's a big indebtedness in the judgment, and that's what we can get to the victims as much as possible is what this court is the goal of this court, so that the victims can be reimbursed. And we're not talking about just an individual, we're talking about the people, the taxpayers, and the children who are all part of the Beaumont Independent School District. What was the total amount of restitution that was ordered?
I think it was around 1.2 million. I'm going off my memory, Judge. The briefs were written months ago and submitted.
Yeah, and at this rate, it would be about 100 years.
Mm-hmm.
So you were required to work vigorously at attempting to find avenues of methods for income to pay the victim. And that is the test. And as long as you or the probation office deems that you are vigorous in doing it, keep it up. And opportunities hopefully will, or more opportunities will arise. Yeah, it's 1.172 million was the ordered at the beginning, and we still have a balance now of 1.15 million. So that's a long way to go. But the jury made a decision, and we're talking, the recipients of this are our children and taxpayers, and they are most important to be reimbursed. What should we do today? Anything from the probation office? We're still awaiting the Court of Criminal Appeals decision on this. And
Yes, Your Honor.
they never tip us off when they're about to make a decision. It just comes out.
They just did one of mine in like 2 months, and then this one's been pending for 5 or 6 months already, Judge.
Well, they get things done, so it may be forthcoming. But anyway, right now, what should any change in what orders the court has made necessary, ma'am?
Not right now.
Probation. Okay. From defense, anything you want to add?
Just, if the court wants him to keep doing the 5 jobs, I think a week will do it. I just wanted you to know he's might have to start reapplying at some point. But we'll leave it to the court.
Well, he has to do what he's able to do.
Okay.
Get reimbursement for the victims.
Right.
And he must make a reasonable effort. And that's the test. But the probation office is, I trust them. They keep an eye on the progress, and they'll alert me if they feel like Mr. Walker is not working vigorously on this. But that's our primary goal. What the jury wanted and what I want is the moment in the school district to get paid back as much as possible in this large indebtedness.
Yes, sir.
Anything else?
I
want to review this in full. We disagree. Thank you. All right. That is all.
Thank you, Judge.
You're good. Be careful.
Yeah. All right.
And all right, let's take up the matter of Devontae Jobert. All right, and you're Mr. Jobert. Yes. With Mr. Smith, your attorney, and the state's attorney is present. And in 23 CR 168, there is a motion to revoke probation that has been filed. Stand by, please. We've got 2 matters on Mr. Jobert, right?
That's correct.
In 23 CR 168, there is a motion to revoke probation. In that case, as the defendant is on probation for evading arrest or detention with a motor vehicle since January 28th of 2025, that is a 3rd-degree felony. He was sentenced to 10 years in prison, and that was suspended, and was placed on regular probation for 10 years. And we have a new case, 26 CR 156, an indictment handed up by the grand jury on January 28th of this year, which alleges that on or about August 30th of last year, going on a year ago, that the defendant committed the state jail felony of operating a motor vehicle while intoxicated with a child passenger. And the child was 5 years of age. All right, let's see here.
I guess this is not ever been beach from the back of the where I guess.
Okay, help me out on this. I'm a little fuzzy on what the plan is. Go ahead.
On the new case, the DWI, he's entering a plea of guilty, and it's an open plea to the court.
Okay.
And we're pleading true to counts 1, 2, and 3 on the motion to revoke. And we have witnesses to.
What is the agreement for the dispositions, though?
So the only agreement, Judge, that we have is that whatever you decide on the motion, that it's going to run concurrent with both cases.
That's right.
The state is seeking pen time on the motion to revoke probation and state jail time on the new charge.
Okay. Let's deal with this motion to revoke probation first. It's the first in time.
Yes, sir.
All right. In 23 CR 168, the state of Texas versus Devontae Corda Jobert. That is you, sir.
Yes, sir.
Present with Mr. Smith, your attorney, and the state's attorney. Does the defendant waive a formal reading of this motion to revoke probation? Can we proceed in summary?
Yes, sir.
And raise your right hand, sir. Do you solemnly swear or affirm any statement made during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lawyer. In summary, this motion states that on January 28th of 2025, so that's what, over a year and a half ago, in this court, you were sentenced to 10 years in prison, and that was suspended. You were placed on regular probation for 10 years for evading arrest or detention with a motor vehicle. Is all of that true and correct, sir? All right. Allegation 1 states you committed the offense of operating a motor vehicle while intoxicated with a child passenger under 15 years of age on or about August 30th of 2025, which would have been 6 or 7 months after you were placed on probation, and that occurred in Jefferson County, Texas, and that is a violation of condition 1 of your probation order, which states commit no offense against the laws of this state or any other state or the United States. It is also what is represented in this new indictment handed up by the grand jury in 26 CR 156 as of January 28th of this year. Is that do you understand what you're charged with here?
Yes, sir.
Is this allegation true or untrue?
True.
It is true. Are you pleading true voluntarily and because it is true?
Yes, sir.
Do you understand that voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant the motion to revoke probation? Your probation can be revoked and you can be sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Allegation 2 goes on to allege this motion to revoke probation that you were at a location other than your residence at approximately 1:08 a.m., which is also, it says, violation of condition 19 of your probation order, which is be inside your home every day between 10 p.m. and 6 a.m. So that was 3 hours busting your curfew. What does he all say? Nothing good happens at that time.
Yes.
Generally. Is that true or untrue? And are you pleading true to that voluntarily and because it is true?
Yes. One and two are sufficient, Judge.
I'm sorry?
1 and 2 are sufficient. I know they planned on pleading to 3, but 1 and 2 are sufficient.
And once again, you are pleading voluntarily, knowingly, and intelligently to allegations 1 and 2, and you discussed all of this with your attorney, Mr. Smith, ahead of time, and voluntarily and knowingly made true to these 2 violations. That is enough to grant the motion to revoke probation, and your probation can be revoked. All right. Everybody has a position on this, and I'll ask the state can go first and last, and I'll ask the defense to also sound in Mr. Smith on the defendant's behalf, and the defendant can also speak. A couple of things I want to ask, though, if y'all will help me, that I'm not giving answers to from this file. According to the report, a blood alcohol test was made of the defendant. A sample was made, and it doesn't show in my file what it came back.
0.165.
165. Okay. Well, that's over twice the legal limit. All right. And also this public safety report that we have to determine. Has anybody seen all of this? Because I'm looking at the public safety report of the defendant. I'm going to make sure that everybody agrees this is what they understand. There was a Senate's report earlier made in this case. Do you have a copy of that? Because we urge that. Well, thank you, ma'am. Okay, that's fine. No. And thank you. Yeah, this is what the public safety report from the Department of Public Safety.
I do not have that.
The blue checks are prior convictions. And Mr. Jobert, you have a lot of prior convictions. How many?
I have 12 misdemeanors, 1 felony.
Is that your final answer?
Yes.
I think the public safety report reflects something different.
All the way back to juvenile.
No, it goes back.
So I got.
But as a juvenile, you're unless you were transferred to adult status,
Okay.
then I'm not going to consider that.
I have 14,
Juveniles
14
can make foolish mistakes, and while they're
14 misdemeanors and 2 felonies.
14 misdemeanors and 2 felonies. Do you think that's too many?
I know it's too many.
When did it become too many? After the first one?
No, when I realized life.
I'm sorry.
When I realized life.
How old are you now?
I'm 25.
Okay. Well, you've been an adult 7 years, right? 8 years. Okay. When did you realize that this doesn't help you and it's not in your best interests, and generally crimes come with victims, and we all to live together in this country peaceably are required to follow the rules so each of us can enjoy the blessings of liberty. Why do you keep making the mistakes? And here we are now, and out of all this, you've committed, after you made a promise to this court, and then within a few months, you're breaking the promise that you would follow all the rules by committing another crime that's similar. It's a traffic offense, and it's involving a child. And too often in this court, we have weeping and crying for mistakes made when people operate motor vehicles irresponsibly. They're nothing more than a 4,000-pound missile and they do heavy tissue damage to people when they come into contact in a wreck. But you know that. And you know it's alcohol. So, I mean, you've got a child in the car. How old was the child?
It was my cousin's son. I was bringing.
It doesn't matter. It's a 5-year-old child, and you have a responsibility when you're operating a 4,000-pound missile, not only for you, the safety of others driving, but also the child passenger. My goodness. Didn't that come across of importance to you? Their life is in your hands, and you're over twice the legal limit of alcohol, which makes you unable to responsibly operate a 4,000-pound missile around town.
Honestly,
There's an old saying, we come in third. Our creator is first. Others are second. We're third. You put yourself ahead of everything, which is irresponsible, but it's selfish. You're supposed to be selfless. All right. Man, it's a child, my God. You know, they're all along for the ride. They can't control what's going to happen. Okay. I think the court has put up what the boundaries here are. So go ahead. The state want to go first, or do you pass?
No, we have 3 witnesses that we wanted to testify for the board.
Go ahead. The state can go first. State can go first and last under the rules. Did you want to defer or put anything on, Mr. Hans?
I would like to open because I want to know kind of where my thoughts are on this before you start hearing evidence. Back when I had this initial case, what Mr. Joubert is placed on probation for, Your Honor has had an opportunity to remind himself of the facts of that offense. The facts of that offense itself is so disturbing. The evading arises out of some indecent exposure that was going on with him out at Lamar, and Lamar was actively looking for him involving those particular instances.
You're talking about Lamar University here? He was around campus? Yeah.
And those are items he was found guilty of from that are marked there as August 23rd, 2022.
That report.
Where he pled and accepted responsibility for the underlying.
Do you need this to just work to? Okay, hold on. Go ahead.
The underlying offense where he's running from these officers on August 23rd, 22 was because they were looking for a guy who was basically working his way around Lamar University and was picking up girls and showing them his junk in order to try to, I don't know, pleasure himself. I don't know. Bottom line was.
Hold on. You're shaking your head, but let me stop you. Let him, he has a chance to be heard and you'll have a chance to be heard. But you were convicted of 2 indecent exposures, weren't you? You know what indecent exposure is? Okay. You don't get it for just taking your shirt off or taking your socks or shoes off. Okay. You got 2 separate convictions here for indecent exposure, which means there were 2 different acts of indecent exposure. Let's see. The arrest date was February 23rd, and you were convicted. And what you get 60 days in jail on each of those, right? Okay, let him speak.
So on the day that this is happening, Lamar is actively looking for the person involved. He runs from the officers. That's the evading, which in addition to pleading guilty to the indecent exposure, he pled guilty to that as well. This is what the officers were looking for, was the person involved with those indecent exposures. Based on his history, having already been to prison twice before on separate matters, I had no intention of offering somebody involved in those facts and circumstances probation. I was convinced by Pastor Adolph to give this man the second chance. And I point to him in the courtroom because I know you're going to hear from him today. And it was through representatives of his that I went against every grain in my being to give him another opportunity. In my opinion, that experiment has failed miserably. He only made it 8 to 9 months before he committed a new offense, which he's pled guilty to you today. So just like the indecent exposure, he's guilty of that. Just like the offense that he's on probation, he's guilty of that. And what he's going to do is continue to offer excuses. You're going to hear from folks, and then probably after that, I'm going to show you, Judge, that at the time in which this offense occurred, he's immediately at that stage trying to convince the officer to let him go. He's already worried about this day in court. When all that goes to not work in his favor and he's sitting in jail getting his blood drawn, that's when we see the true Devontae Joubert. I've got that video for you to see as well when it's my turn, Your Honor.
Okay. Now go ahead, Mr. Smith.
Mr. Joubert, let's talk about you were.
He can ask you questions. Remember, you're still under oath, sir. Okay. Thank you. Go ahead.
Placed on probation back in January 28th, and it was evading arrest. So if you tell the court that this first off, many times have you been convicted of a felony?
Twice. I've been in prison once. He said I've been in prison twice.
So you've been in prison once. All right.
No, how many felonies? You said 2. You got 2 felonies, which are
the one I'm on probation for. The robbery I went to prison for.
You've got a robbery conviction and then the evading arrest or detention.
Right.
That's all probation. Yes.
Okay. That robbery was back. That happened about, God bless you. You were arrested in 2019. And go ahead.
Now, explain to the court what the situation was regarding the Lamar University and all that at that time.
The situation was I was driving down Captain Street, and a Lamar police officer was going this way. I was going this way. They said they tried to pull me over, but I'm going like this. So when I get to the light, it's a red light. They have 4 police officers pass me up. The light turned green. I drive when it turned green. I turn on my street on Alabama, and I jump out my car and I say, "What's going on?" The reason why I pled guilty is because this man. He say every time we go to court, it's personal for him. Why am I personal to you? Every time I come to this courtroom, I'm standing here, I'm doing this. He's saying, "Oh, it's personal." Why do I got to be personal to you? I understand all this.
Wait. That's why you pleaded guilty?
Man, because I don't want to fight him.
That's not what you said. Wait, hold on. Maybe you ought to talk to Mr. Smith. You're digging a hole right now. Because during the plea hearing, you take an oath.
Right.
And I even asked you, are you pleading guilty because you are guilty? And your answer is yes, under oath.
Yes.
And in the papers that you sign under oath, yes, I have committed each and every element of this crime. I am guilty of this offense and any lesser included offense.
Sure.
You're telling me today that, you know, we can't speak over each other. She has to take everything down and let me speak when I speak, and then you give a fair opportunity. You see, you're not following the rules again, and it looks like you want to be in control. And here's the problem is you're telling me that you pleaded guilty for a reason other than contrition and that you were guilty because of somebody else doing something, which is violating your oath. That's perjury. And I'm going to ask them to look into that. Because you're under oath now. But everybody who pleads guilty, if they're doing it and not following the oath, then they can be held accountable for another crime because we don't want to make fiction here. We're trying to get to the truth.
Judge, if I may.
This was brought up before. Mr. Ham asked me to independently look at the file, and I looked at it, concurred with his assessment of it. So it's not personal. It's something that we both believe is fair and just.
Well, but it goes down to what I make a decision over, and the paper is a document that you have sworn to that says, and I even asked you, are you guilty of this crime? Because you are guilty and for no other reason. You're coming up with something else. And that's perjurious.
The confusion, Judge, is that he's not talking about the evading.
He said I'm sorry, he said he pleaded guilty.
He was talking about those misdemeanors.
Okay, even that is the same
But
thing.
that wasn't before.
It doesn't matter what crime, when you plead to crimes, it's all the same. You have to admit you're pleading guilty, not I'm pleading guilty for other reasons. That's so people later don't come back and say, oh, I want to change this now. And you have it, and you had a representation by attorneys, right?
Yes.
Okay. Well, they know as well you can't be doing that. So that's why the truth is important, or else this is a farce. We try to get to the truth. But when you're making a plea, you don't do it just for convenience. It's because you're accepting responsibility for your actions. So talking to me now about I did this for some other reason because somebody said something to me or something, that confounds the whole thing that you were on probation for. I mean, all that does is dig yourself a hole in more trouble. And perjury is a terrible crime. You've had enough crimes here.
Which, do you remember which
and take responsibility?
Those misdemeanors as far as the indecency?
Clinton Woods. Mr. Judge
Woods?
Yes.
Judge Woods? Okay. And on that night of the evading arrest, I mean, were you guilty of going around and exposing yourself to women?
Yes.
Sorry.
Yes.
And so that's why you did that. But after that, you accepted responsibility on the evading and were placed on probation.
Right.
Tell the court now what is.
Hold on, let me stop you just for a second. Why would you do such a thing?
It didn't go down like that at all. And it just been.
Tell the court what it did.
It's not.
How it went down.
I really don't remember the situation.
I can't.
I just let it go.
What, were you drinking or something?
No.
Oh. You were sober and did this?
Tell the court what is going on with your life now.
I've been out since December 17th. When I got out, when I was in jail, I said, I talked to myself and I got the same paper you guys got with all my convictions, all this, all that. Seeing my daughter come and visit me, seeing my mom crying, and I just made oath to myself, hey, I'm done.
You have children?
Yeah, I have a 3-year-old girl, a 5-year-old son, and a 6-year-old son.
Hold on.
I was sick.
Hold on. You have a 6-year-old son?
Yes, sir.
Okay. But you still committed these crimes, some of these crimes while you had children at home?
Yes, sir, I did.
It's not enough that you can look into their eyes and see that your actions will affect them. And that when you do bad things, they're going to be adversely harmed as well.
Right.
And what is the greatest gift to your children?
My father, I feel like,
Sir?
my father, because I didn't have
Your greatest gift to your children
you can do that.
is to set a good example and to be a role model, because they're going to emulate what you do.
Right.
That's a natural phenomenon.
Right.
That's why you don't live just for you when you have children.
Right.
You live and you become third.
Right.
The creator is one, others, your children second, and you come in third. That's selflessness versus selfishness. But here's the deal, you can always stop. and B, that act correctly and responsibly. Maybe this is your time, but for far too long, you have headed in the wrong path and made excuses, not accepting responsibility. And you did that today. But
on the night that you were arrested for this DWI, you're pleading guilty to. You told the officers that you had a couple of drinks, right?
Right.
And you did not feel that you were really intoxicated until I explained to you what the legal definition of intoxication was. And so you agreed with me that technically you were intoxicated. You don't believe, we've had great discussions, we've talked to an expert. You don't believe that 0.165 is accurate.
Right, but I knew, after I spoke to you, I knew that I was physically not myself. So that's why I played to it.
Because you had lost some of the use of your mental and physical factor.
Yeah.
All right.
So when I was explaining it,
Go ahead.
we about to show a video that night.
Go ahead.
The night I got pulled over, it's the same officer when I went to prison. And then I had a conversation. I was a trustee in Jefferson County. We had a conversation every day he come to work. You know, when I used to talk to him and tell him, hey, this and that. And the night when he pulled me over, and I'll be honest with him because I knew him. He asked me, hey, have you had some drinks? I said, yes, sir, I have, you know. And he told me to get out, did what he had to do. I agreed to everything until he told me he was taking me to jail. That's when those videos come of me doing belligerent, cursing, talking crazy because my feelings were hurt.
Because what?
Me talking belligerent, crazy, and everything because my feelings was hurt.
Your feelings were hurt.
Yeah. And so that's when all this come from talking crazy.
What do you mean your feelings were hurt?
So because me and him had a conversation and he used to always tell me, hey, you're capable of doing better. You're capable of doing this and that. And you're taking me to jail. But you know, I coached him out and did all that, went back and forth. But as soon as I got out of jail, I reached out to him, called, met him at the police station, apologized to him, told him, I understand how wrong you were doing your job. My bad. You know, I'm going to do better. And he accepted my apology, you know. But the thing is, he's trying to show this video that I'm just this guy, you know. But like I said, I went from, it took me to go back that time and see my daughter through this glass, crying, you know, and all this and that. When I got out, I started doing the right thing, and I just got blessings after blessings, you know. I got a brand new house out this board. I have contracts with Walmart.
Your new house, what is the address of that?
7895 Kimball Circle.
Is that here in Beaumont?
Yes, behind Populos.
And do you have your own construction company?
Yes.
And what's that called?
DJ's Redeem Construction.
As a matter of fact, concerning the construction company, you just finished a construction job at Antioch Church, is that correct?
Correct.
And also, are you a manager of, you have a separate job of being a manager of Airbnb property?
Correct.
Okay. Are you also part of a nonprofit organization that's called Dr. Violence?
Correct.
Could you tell the court what type of organization that is?
So even though I'm going through everything I'm going through, knowing I got to go to court, not knowing what's going to happen, I'm still out there going, trying to talk to you and tell them, hey, my situation, I'm doing this, I'm doing it, you know, because at the end of the day, regardless of what happened, I know my heart standing in this situation now. I know that this is my last time standing up for it.
But you still have to accept and deal with the responsibility of your mistakes.
I accept it.
Okay.
And on this evading that you're on probation for, that was not a high speed chase. Is that correct?
Yes.
That was just explain to the court what
was me driving to my house.
Okay.
What's simple as that?
We weren't speeding.
No,
anything of that.
It's I'm straight to my house.
All right.
But hold on. But you committed the crime of evading arrest, right? It can be committed in ways other than speeding. Okay, because it's a 4,000-pound missile. If you're doing 10 miles an hour, people aren't going to stand in front of you. You're going to roll over them.
I said I did.
You committed the crime. Okay, it may not have been egregious, but still, when the police have the lights, siren, you got to pull over and deal with it. Not on your terms, but on the law's terms. Okay. You'll be done with it.
So in summary, tell the court where you think you are. Why do you feel that you're asking the court to continue you on probation?
Right.
And why do you feel that the court should give serious consideration to that?
Because I don't usually come up here and talk. You know, what y'all do, what y'all gotta do, and I'm a silent, I'm going about my day. I'm up here fighting for my freedom because I'm done. And personally, and I know this might sound crazy, I got to point the finger to this man because he think I'm a failure. He think I'm not gonna make it. And I got a point to prove. I got kids, man. And
wait, you said what did you just say? You have
kids.
Didn't you have children? You were committing these crimes.
I had to realize myself. It doesn't. I understand I had, but at the end of the day, I was just still caring about myself.
Okay, it's never too late, but you still have to pay the responsibility for committing the crime. Okay, all right.
Anything else that's what I add as to why you want the court to consider continuing you on probation?
All I can say is I'm gonna let my actions speak for itself. I'm done. Y'all got me. Y'all got what y'all gonna get out of me. I'm done. Not gonna see me no more.
Okay.
You can imagine. I wish I had $1 every time I heard that up here.
That's understandable.
But just walk the walk. Don't just talk the talk. Okay. Go ahead, Bruce.
I've asked the witness.
Anything from Stone?
Yes.
Go ahead.
May
Yeah.
The PSI judge. All right, so let's try to do this in an orderly fashion. Yeah, that's the unfortunate side. When you decide to talk with the court, you have to also answer my questions. According to, let's deal with this chronologically. You have a juvenile history, and the reason why that's relevant, sir, is the fact is in 2016, you committed 2 felony offenses, theft from a person and unauthorized use of a motor vehicle, which resulted in you going to what's commonly known as TYC. Remember that? What you may not be familiar with is that underneath the law, that can and would be used against you as a felony conviction. Should have been told to you that back when you dealt with this when you were a juvenile. You understood that? Yes, sir. Okay. So you received a probation from this judge for the offense of robbery back in 2019. And that was revoked. And I happened to be the attorney on that whenever you appeared in court and you received 4 years TDC, correct? What?
It was revoked for what?
That's my follow-up question. What was the motion? Do you remember on the motion to revoke as to why?
Yes.
Why you were revoked? What was it?
Because I didn't show up for my weekends and I had a whole bunch of theft charges.
Okay. And that was in 2019 was the original offense. You were actually revoked in 2021, right?
Yeah, because of children.
Right. That was August of 2021. And then a year later, you're involved with these offenses that we've been talking about with the court, correct? Let's talk about that next. I'm showing your lawyer the PC affidavits for those 2 indecent exposures. These are court records, so they're admissible on that basis. Hold on. Do you have any objections?
As those are official government documents, I cannot object.
Okay.
There were two different women, probably the state's exhibit 2.
However, I do object to the hearsay contained within.
Hold on. Now, what are you referring to?
These are probable cause affidavits on those.
On the 2 matters he's pled guilty to and got 60 days jail time.
Okay.
These are the indecent exposures.
Okay. Well, at the time, when the, was a pre-sentence report made in that?
On the misdemeanor offense? No, sir.
But on this case, there was. On the evade.
Okay.
So I'm going to ask him 2 questions on that, and then I'm going to hand them for your review, Judge. There were 2 different ladies involved with claiming that you exposed yourself to it. Do you agree or not?
I agree.
Okay. And these happened back on August 23rd, 22. They're on Lamar campus, correct? Ms. Horn has said that she approached your car, you were sitting in the driver's seat stating, let me show you what you're missing out on, and exposed your penis to her.
I don't agree.
You don't agree? Second lady, Miss Menino, stated that while you were driving, she glared over at you and saw you exposed your penis and you began masturbating.
Why would she be in my car?
And then you stated, I don't know, I don't know what you thought this was.
The thing is, why would she be in my car?
You don't get to ask me questions.
But you can ask me questions.
Yes, sir, I can. Did you say that to the lady?
Yes.
And you were masturbating on that day?
No.
That all precedes the event where you are arrested and charged with the offense of evading arrest.
Okay.
Do you agree or disagree?
I agree.
That those 2 incidents that the judge will read in the probable cause, that's the reason why Lamar was looking for it.
That's understandable.
Do you agree or disagree? Officers in this deal, despite what you said in the PSI, which went unobjected to, said that you sped off at a high rate of speed. Do you agree or disagree?
Disagree.
That you disregarded all stop signs and the safety of others in that area, including kids on the bikes.
Disagree.
They did say that you finally stopped at 400 block of Alabama Street. That's the one thing you agree with, right?
Yes, ma'am. But can I say something?
Go ahead.
Why don't you, before you say that, talk to him privately so nobody can hear you, so he can give you advice. Thank you.
Okay. Well, you just read all my criminal history. One thing that you didn't mention, is I understand because it's your job, about the gap in my criminal history. Therefore, what I mean by that is this: juvenile all the way to 2021. I didn't stay out 30 days. I was back and forth in jail. You catch me when you catch me. This time, motion to revoke with this DWI, I called my probation officer and told my probation officer, hey, I caught a new charge. I called you guys every day to see when I had a warrant for my arrest. They didn't have to chase me. I wouldn't turn myself in. So it's things that you're saying, and I understand it, but people change.
You pled guilty to the offense of evading arrest.
That's cool.
I've stated to you for the record what the officers allege. You're disagreeing with that.
Right. No, I'm agreeing to, I plead guilty to evading detention in a motor vehicle. Because that's what happened. If they say I ran, I drove to my house, but I'm not pleading guilty to the things that they said that I did. It's a difference.
The 2 things I'm concerned with is that you were driving at a high rate of speed and disagreeing with stop signs.
No, sir.
You disagree with that?
I disagree.
But you pled guilty to the offense.
Because I evaded from him. I went to my house.
You know that you cannot legally do that, correct?
It's called illegal.
Sir?
You say I can't illegally do what? Drive to my house? If I'm nervous, you got 4 or 5 laws behind me.
That's the mistake that a lot of people make. That is not a proper thing to do in the law, sir.
That's understandable, but I asked you a question about the gap between my criminal history.
All right,
You're bringing up everything that I've been doing or what I have going on, and you're not speaking the facts that you know because you don't, you, like I said, you have it personal out to me. I have recordings of you saying this on Robbie right here. This is personal to me.
Pretty much what I have said on the record, and it's clear for the court's record, is that I do feel like when I gave you the opportunity that gave you this chance, and I said, I feel like I've got egg on my face. I do feel like I went out on a limb for you.
But then the day,
and frankly, Mr. Juber, it's not personal. What it is I do feel like you failed.
Right.
But so let's talk instead about the offense. Okay?
I'm not worried. We already discussed offense. What I'm trying to make clear to you is this, Mr. Ham.
Hold on. Hold on. You don't get to decide how the hearing is. Please stop. It's you don't follow the rules. You have a fair opportunity to be heard. He, by his oath and his job, he can inquire. He's a prosecutor, and they can inquire representing the people.
Yes, sir.
And you may answer or not.
Yes.
And then Mr. Smith gets to put you on, and you can put the whatever evidence you want. But you don't decide the way the hearing works. I mentioned that you like to be in control, but this doesn't show that you're really doing a good job on control and making the right choice. Which here's what's disappointing. I think you're capable of it. You're capable of success. That's why I'm frustrated that you've had this many mistakes, because you seem capable, and I hate failure. And especially people who are capable of doing better. He has a right to ask questions by his job, and you may answer or not, and the court gets to determine what weight and credibility is to be given by the evidence. But you don't get to control the proceedings. The state can ask and do its thing, and then the defense can, and then you have a fair opportunity to be heard.
So let's shift gears to August 30th. That's the night you were arrested for DWI with a child.
Right.
Have you watched the videos contained in discovery that's been provided to your defense counsel?
Yes, I watched it, and I explained to you because
I'm not asking you to go into an explanation.
Yes, I watched them.
All right. So hang on. Do you recall that the officer, after he placed you, or after you're talking to Officer Weeks right there at the patrol car,
right,
he leaves you there for a moment and he goes to talk to the passenger? Do you remember that?
Right.
Do you remember what he asked her?
Where did we go? Well, he didn't tell me what he asked her.
Right, but you've watched the videos.
He didn't tell me where he went. The only thing that I know, I was belligerent and I was acting out of feelings with him.
Do you remember when she told him that you were drunk whenever you showed up to pick her up?
Correct.
Do you remember her detailing all the amount of drinks you had before and after she got you?
Correct. I'm not saying I'm not taking responsibility for that. I did it.
And all those were different from what you told that officer that day.
Correct.
Right.
And I went back.
Second thing, isn't it true, sir, that whenever you realized that you knew this officer, that you were trying to avoid this whole thing, not be arrested?
Yes, sir. I was asking him, could I call somebody to bring me home? I'm not saying you're wrong. That's exactly what happened.
All right.
You know.
Did you watch the video that when your blood was being drawn at the jail?
Yes. Did you see how many times they stuck me?
Sir, well, how would you describe your attitude that day?
Belligerent. I was going crazy. I was in my feelings.
And what were you calling people?
Everything in the book.
And do you think that what your action was appropriate?
No, I know it was not appropriate. That's why I took the steps to go apologize to him like a man.
There was more than him involved.
Both of them and Roy Carroll got an apology from me.
What about the nurse?
The nurse, I spoke to the nurse when I went to jail for my motion to revoke probation. She's the one booked me in. I apologized to her first.
You were belligerent and offensive to Officer Weeks?
Correct. The other officer and the nurse.
Officer Tyler?
Correct.
And the nurse?
Correct. I'm not saying I wasn't. I'm telling you.
Not acting like you are today.
Because at the end of the day, I learned from my mistakes and I want to apologize to them. They accept my apology and we moved on with life about it.
I have no other questions.
I got one more thing.
He'll ask you and he'll give you a chance.
It's a statement.
Go ahead.
Mr. Ham, it's nothing against this. I understand you doing your job. but I'm not a failure, and I'm gonna prove you wrong. And regardless if I go where I have to go today, or the Lord let me go home, I'm gonna prove you wrong that I'm worthy of being on this earth and doing what I have to do as a man. And that's that.
Wait.
You and I have discussed.
Hold on. Hold on. I'm a little fuzzy about what's he wrong about?
No, I didn't say he was wrong.
Well, he said you're gonna prove him wrong.
Because he said I'm
I mean,
failure.
isn't,
He said I'm a failure.
well, you were failure on probation is what he says. And by committing these violations that you've admitted to. Okay, and nobody's saying you're a failure. You're capable of doing great things. Just make those good choices.
Oh, sir.
Go ahead, Bruce.
You and I discussed on as far as what you were placed on probation for, the evading, and that, I mean, there is an offense called to elude, which is a misdemeanor, which is failing to pull over, when officers are instructing you to pull over. And you explained to me that is what occurred that night. You failed to stop when the officers were behind you, because you wanted to get to your house. But there was no high-speed chase, is what you're saying. Is that correct? All right. But after being, explained after you and I were talking about this, you agreed that technically you did violate the offense of evading for failing to stop.
Right.
All right. Is there anything else that you would like to tell the judge?
Like I just told you before, my actions don't speak louder than my words. He done heard it multiple times, but if I say I'm done, I'm done. I got too much to lose right now.
Yeah. Oh God, yeah.
That's all I'm saying. But
are you supporting your children right now?
All my children stay with me.
All your children are with you?
Yes.
And that's at the new house, 7895 Kemper Drive.
Right.
All right. Is there anything else?
That's it.
Yeah, I've asked witness.
What happened on July 28th, 2026?
July 28, 2026?
Yes, sir.
Probation?
Yeah.
Okay, I went to probation. I went to probation, completed my MTRP class, went to do a UA, failed for alcohol, brought her my paperwork from my doctor.
That says what?
That said that this is promethazine that has 7 to 8% and will fail in the urinalysis.
Okay, so this is prescribed medication.
Correct.
And you presented to the probation officer the proof
Yes,
that this while you're taking this medication, if you were to take a urinalysis, it will show alcohol.
When I first was sick, during February, I presented it to her, but she said she didn't have it no more. So I went personally myself because the urinalysis lady was arguing back and forth with me. So I made it to go to my doctor, and my doctor wrote a report saying that, hey, this is, this will fail. And I brought it to her, and that's what it was.
Yet you had not consumed alcohol.
Right. I have not drunk. I got a breathalyzer in my truck that I blow in every day.
All right. So since I was the one asking questions.
Go ahead.
On July 28th, you tested positive for alcohol.
Mm-hmm.
It was after that day. You argued with it, and you said, I've got reasons. And you came back and you brought them a medical excuse. That was done when?
Medical excuse was done February.
When did you bring it back to them?
The same day.
All right. You didn't have it on your person when this happened.
This is already shown to her.
Sir, I don't want to argue with you. I'm just asking for a yes or no answer. You came back with the doctor's excuse.
Correct.
Right? I got it. You're saying that you had that before and you gave it to her before.
Right.
You're telling the court she told you that didn't happen, that she didn't have it, right?
Yes, she told me. I sent it in an email, a picture of the prescription bottle. But the lady that takes the urinalysis, she told me, no, it's an opiate. I went to my doctor.
Promethazine is, sir.
Not oral, not liquid promethazine, sir.
Right.
And I went to the doctor, and the doctor printed out a paper and say, hey, they can say what they say, but I'm a doctor.
So your excuses for that incident is what you told the court, much like your excuses about indecent exposure, the evading, and now the DWI with the child.
The thing about it is I'm not taking excuses. I'm taking responsibility for those.
with explanations.
That's not an excuse. That's exactly what happened.
Right.
Not an explanation. I'm telling you I did it.
Yes, sir.
You trying to get me out of my character. I'm telling you I did it.
No further questions, Judge.
Anything, Bruce?
Nothing further. We have three witnesses that we'd like.
Okay.
We call Pastor Adolph.
How do you want to do it? You want to do it at the table?
Yeah, he can come up.
What can I say? I'll close it out. Once again.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hands. Go ahead.
For the record, sir, would you state your name?
My name is John Adolph.
Okay. And could you, for the record, could you also just tell us what you do for a living?
I am the pastor of Antioch Missionary Baptist Church.
And that is the same church that he just recently did some work on, construction work at your church.
That is correct.
Could you tell the court what your knowledge of is of Mr. Jubert and what you would like to tell the court about?
Judge, I've been the pastor of Antioch for 30 years, and I've known Devontae for 28 of those years. His childhood, young ages of adolescence, young adulthood have been peppered with problems. His family sits on the same pew every Sunday, and I've watched him grow. I've watched him make so many mistakes. He has been the kid for me, and we've always had to keep an eye on. Always had to say, but where is he now? When I ask for, grace and mercy towards him in his last condition, I just knew that he would be able to stay on the straight and narrow. The DWI that he had received was very hurtful to me. I was very disappointed. When I look at his past and consider that charge, my mind said, he's doing so well. It is why I'm in court today, because this is the best version of his personhood that I've ever seen. I have preached to him issues of honesty, transparency, integrity, and responsibility. Every time we talk, I say, where are you? What are you doing? How's it going? And right now, this is the greatest I've ever seen him as a young man. I think it has taken all that he's been through to get him to where he is today.
The court's decision today is to revoke his probation and put him in the penitentiary, or not revoke his probation, but continue him on probation and not put him in the penitentiary. What is your feelings about those choices?
Hold on. And there's a second case that is a felony and options of probation or
that's the DWI.
Or options as well.
What are your thinking? What are your thoughts about as to what he should? Any kind of guidance you give to the court as to what he should do with Mr. Jubert?
One, I think that if he's shown leniency, grace, and mercy, I don't think you'll ever see him again. I think that right now, I feel in my heart that he's the man that I've been praying he'd become. Get up, go to work, come home, love your wife, take care of your children. Where are you? What do you do? And to move him forward. I don't think you'll see him again. I think he's reached a limit on whatever he's done before now. Will he be perfect? No, hold on. I don't want to paint pictures of pseudo perfection. I think that'll hurt us all. At the same time, I do believe that he'll be in a lane that pushes him forward and really cause him to be a good, productive citizen. I believe that. When I check with him, I've talked to him almost every week. Right now, we have a little over 6,000 people in our church. And I've just taken him under my wing to say, where are you? What are you doing? And how's it going? Where are you working? How's your children? And what I hear from him consistently makes me feel like
if we give him another chance, I don't think we'll see him again. Thank you. I'll pass the witness.
Pastor,
Yes, sir.
I didn't realize you had a flock of 6,000 people.
Yes, sir.
I know you're a busy man. And I want to get, you and I have not one-on-one visited about this young man.
No, sir.
All right. First off, great book. Come to the table. When are you and Bishop Toops writing another one?
I hope that soon. He's going to have an ecumenical gathering, and I will be away in Nevada in revival. I'll have to miss it, but I was hoping to be there. They changed the date. We had a date set for this wonderful ecumenical luncheon, which I think we are way overdue for.
Yes.
And no one could do it, I think, like Bishop Toops could do it, to just bring all of these denominational heads together, sit and talk about what we can do to make Beaumont great. And I was looking forward to it. So I don't know when we'll author the next one, but I hope it'll be soon.
So I mentioned,
just if I may,
yes, sir.
I hope that not only the prayers, but also that some thoughts to be given to help us, me and others in the criminal courts. We're the 21st largest county in the state with the 15th highest crime rate. And we are busy here, and we can use all the help in prayerful guidance as we can give. So thank you for, because this is not an evil county. It's wonderful. We've got a work in progress, and we all have a part to play in helping mitigate the crime, the crime epidemic that we have. And there aren't many counties that have a proportion of crime based upon population that's high like Compton. And we're working as hard as we can, and we need all the help. Spiritually.
Yes, sir.
I believe it works. So go ahead.
Thank you, John.
I too honor shepherds.
Thank you.
And I know that your flock is huge, and I know you do a lot of hard work. That's why I mentioned my shepherd was Bishop Toops.
Yes.
It's tough when you've got that. And one of the things that you've stated, there's several things that are ringing really close to my heart, and I want to go back to it. When did you start taking such a personal approach that you described to Mr. Smith with Devontae?
I would think when his mother came to me, and I don't know which one of those incidences it was on, according to that litany of things you all shared about his past, but his mother would come to me on a regular basis. We have prayer cards at our church, and people fill them out and they send them to me.
Prayer intentions.
Yes. And I would get one with his name on it. That's how I got to really know. His family would sit on the second pew to my right every Sunday, and there'd be these little boys sitting there. And so as they grew up, she would always tell me, please pray for Javonte. Please pray for Javonte. So it became just almost like a chorus. Pray for him, pray for him, pray for him. And her burden became mine. I don't really know the exact time or date, but that burden became something that I would take home, and my wife and I would pray for him.
Good. And obviously, no matter what happens, you'll continue to do that.
Absolutely.
Right. And we both can agree there's only been one perfect man in this walk, this earth.
Yes.
So the rest of us are just striving to do the best we can.
Yes, sir. Yes, sir.
You did not personally talk with me before I offered him the probation on this case, but you did have others come and approach me on his behalf.
Yes.
Right?
Yes, sir.
And you know that efforts were made with your name attached to give this man another opportunity.
Yes, sir.
Were you advised that that was done with an extreme amount of reluctance on my part?
Yes, sir.
Were you advised it was solely because your name was attached to it?
Yes, sir. Yes, sir.
Was it after that that you started to watch him?
Yes, more so then. And to really try to make sure he was in worship on a regular basis.
Yes, sir.
And to make sure that he was really bearing down on what he should be doing. the evening of the DWI, should I say, the early morning of it came as a shock to me.
Right.
I was disappointed and shocked.
You described it as a disappointment.
Yes, sir.
I had that same thing, and you've heard the discussion he and I've had. I don't see him as a failure, but I see that as a failure.
Yes.
Don't you?
Yes.
I mean, because it was based on your words, your reputation, and the ability that he would follow.
Yes.
But he failed in that regard. He failed.
Absolutely.
Right?
Yes, sir. Yes.
Is there anything you could have done differently to prevent that?
Well, when I spoke to his mother about that very evening, he was just kind of wanting to just get away and to relax and just be with his friends.
Celebrating a recent graduation.
Right, right. So when I spoke to his mom about this incident, she said, Pastor Adolph, I cautioned him to stay. She said, but he really wanted to get away and just live a minute. He felt like he just wanted to just be able to laugh and talk. And I said, I understood that. And I just wondered in my heart and my brain, at what point was one too many? When did he lose control of that moment? I've always just thought about that. And I've cautioned him on it. My father suffered with alcoholism for 31 years. So it's one of the reasons I don't drink, because I know the demon that it can be. So I just often played it back in my mind. And I spoke to his mom about this on at least 3 other occasions before today, just talking to her. What happened, this, that, and other. And had he not gone, we wouldn't be here today. He'd be doing, just on the straight and narrow. Had he not gone, the video, because he mentioned that to me, he said, Pastor, I was really out of character on this video that they took. And I said, well, what I want you to do for me is be honest. Don't sugarcoat anything. Be transparent, be honest, take responsibility for that. And I just wonder what would have, this day would have never really been this day without that moment.
Can we agree that had he followed the rules of probation and ceased his celebration before 10 o'clock and gotten home, we probably wouldn't be sitting?
Yes, sir.
And if he'd followed the rules, obviously we wouldn't be dealing with this.
Yes.
Follow your advice, his mother's advice, we wouldn't be here. But he's a grown man and he made his own decisions. True.
Yes, sir.
All right, so let's talk about the second thing that you talked about. And I think you and I can both agree on this. It's important for a man to have integrity.
Yes, sir.
Do you think this man here has expressed integrity specifically in his actions just today in court when he's been arguing with me about doing my job in them?
I think that he has been just to a push to be emotional. I think that he wants the truth to really come out. And it's so much layered. That's why I talk to him so much, because so many things are layered. It's almost like peeling back pieces of an onion.
So what layer are we missing?
I don't know if we're missing them. I think that right now what I wish, we had the time to do is really figure out what really happened. Like so many times I wanted to ask him now, what happened with this? And what happened with that? And the story is always just layered, So I would reach to say that as I listen to him talk to me.
2 and 3.
What I would reach to say is that as we listen to him talk today, one of the things that I've really been pleased with is he hadn't tried to hide anything. I don't want him to hide anything.
I'll show you what's marked as State's Exhibits 2 and 3. These are the probable cause instances where on August 23rd, 22, he was using, at best explanation, a really bad way to try to pick up girls at Lamar University. One in which he exposed himself and told a young lady, this is what you're missing out on, and used the same line similar as he masturbated when he had another one in his car. Is that a man of integrity?
So,
did he tell you about doing those things?
I heard about the case at Lamar. I did not know about the intricacies or the intimacies of this man. No.
When we have integrity, we admit our mistakes and we come and we talk to it. And I don't want to get into confidences where you may have shared that information, but you didn't know this detail.
No. I knew about the case at Lamar University a few years ago, but I did not know about the specific allegations that are listed.
Thank you, Pastor.
Pastor, you heard this morning, he's been make sure that the court realizes he's taking responsibility and he's telling the truth. And you heard him argue with Mr. Ham about the things that those two women, some of those things that those two women simply not. And like even the officer saying it was a high-speed chase, he says that did not happen. I just did not stop. You heard him tell his version of what happened that night. Is that correct?
That's true.
And the thing that on the night of this DWI that he was celebrating, he had just graduated.
Yes.
He wanted to, and he made the mistake of being with his friends to celebrate that graduation.
Correct.
And where he got his commercial driver's license all the time.
Correct.
Which was a big step, for him.
A milestone for us.
Oh.
That wasn't the mistake he made. It was operating a motor vehicle with a child. A child passenger while intoxicated. Not one, but two people were put in jeopardy there, and a child who just goes along for the ride. And it's our duty, our responsibility to protect them. You had two souls in that car. Yeah, go ahead.
Is there anything else, Pastor, that you would like to tell Judge Stevens that we haven't covered?
No, there's nothing else that hadn't been mentioned that I can think of that comes off the top of my head, other than the fact that I'm proud of you being honest today here. I'm thankful for you to be transparent, honest with integrity, and take responsibility for the things you take responsibility for. And in my mind, that's good Christian manhood. Stay on this street no matter what happens. And this is the boulevard that I think you ought to be on. This is the street that I think leads to things that will lead you to favor with God. I'm very proud of that. I don't think you've tried to cover anything, mask anything. And I feel for certain in my heart that if we show him the type of leniency that I think that he could gain or possibly gain, that we won't see him again.
I have nothing, brother.
Anything else?
No, thank you, Pastor.
Thank you, sir.
Thank you, Jim.
Anything at all asked to add by the parties?
Yes, I have what's called AJ Turner.
Come on. And raise your right hand, sir. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir, Judge.
Please lower your hand. Go ahead.
For the record, sir, would you please state your name?
I'm Albert AJ Turner.
All right. And Mr. Councilman Turner, what do you do for a living?
I'm a city councilman, elected official, and an entrepreneur.
All right. Could you tell the court what is your involvement with Mr. Jubert and with the things that you would like to inform the court?
Well, I look at him like a little brother. He's a kid I kind of been mentoring on and off since he was in high school. And often, I just rather be factual. We have young black men who don't have other black men they can look to that are guiding them, giving them the proper direction and showing them this is how things can actually be done. But he literally sits 2 rows in front of me at church. And I remember seeing him start off at church by himself. But I also been seeing, as of lately, he's coming with his kids. And that really resonates with me.
And here, how long have you been involved with him?
Man, since he was in high school.
Okay. The man that he is now, I mean, you heard him testify that he just bought a new house at 7895 Kemper. He has his own construction company. In fact, he just finished a job at Antioch Church, and he's a manager at Green Properties, and he's highly involved in a nonprofit organization called Stop the Violence.
Mm-hmm.
Is this the man that you see now? Is he a difference in the magic who's known to pass.
Yeah, but like most young men, I watch the cycle and the system, and I understand the way systems work. They get in trouble, and often one of the biggest things that I try to teach is accountability. I see people run from it. I see them make excuses. I even see them get emotional today. I almost want to get up and say, calm down. I literally wanted to. That's why I'm doing it now. But taking accountability is hard. And even people who you look up to, hearing some of these things about you are even harder because we pass a lot of judgment in life. So I think one of the toughest things for him is even me being in the crowd, hearing some of these things. But who I am, I used to be a parole officer. I try not to get caught up in who somebody was, and I focus on who they're becoming, and I try my best to work with them to make the best version of them. But I do understand if you make mistakes, you have to be held accountable. So what I have seen him develop into, even him telling me he was ready to get married, I was kind of shocked when he gave me a phone call when he got his first contract at Walmart. You know, he called me excited about it. And I'm like, you know, just to see where I knew he was at, all the mistakes and things I knew he's done, and to see where he's going, it really shocked me, made me feel good about it. But when I heard about what happened, it was definitely disappointing.
And the man that you see, everything that he's doing now with his life and taking care of with his children and all of that, is that the type of man that you're convinced that if this judge was to see fit, would give him a second chance and allow him to be on probation, that we would not see him again before this court?
Yes, I feel good about it. But my biggest thing is, even for myself, I try to look in the mirror and I want my kids to look at somebody that they aspire to be. And that's what I want to tell them today, the way his kids look at him. If the kids knew some of these things, that mistakes he's made, you want to make sure you're making a proper decision so you don't discourage your kids or you can't be around good kids, because I see him love on them on Sundays. I see him hugging them. I see his arms around them, man. Just to kind of watch that, it's just tough to hear what's going on today.
Is there anything else that you would like to tell Judge Stevens in this decision that he has to make as to whether to put him in the penitentiary or to allow him to be remain on probation?
Well, Judge, it's hard to deal with these type of instances. Even the emotion he showed earlier. As I stated earlier, I wish I could have walked up here and said, calm down, you got it. But what I'm most proud of is when we talked about this, he said, I'm taking accountability. I'm not making excuses. I'm admitting to what I did. And whatever the results are, I'm just going to live with it. And a lot of people don't do that. Mm-hmm. You know, everybody's looking for a way out. And just to have the level of maturity to say, whatever the results are, I live with it. And me coming today was based upon what I've seen in his growth. You know, when you see a brother fall and struggling, specifically brothers who might not have an older brother or father figure, me as an older man, I want to grab him and pull him up. I don't want to leave him down there. People ask me to come speak often. I won't, because if I can't physically see you're making improvements and doing the right thing, the last thing I'm going to do is attach my name to that. So that's why I chose to come today, because I have physically seen it. I've seen the growth. I've seen what he's doing in business. I understand celebrating when you accomplish a milestone. But like Judge said, the celebration wasn't the issue. Choosing to drive the vehicle was the issue, specifically with a kid in the car. But you having kids, I definitely understand that as well.
Thank you, sir. I have nothing further.
Yes, sir.
Thank you.
I have a few questions, but before we get started, my memory is that, have I represented you in the past?
Me?
I'm just checking.
No, sir.
It seems like every time I'm confusing you with someone I dealt with, and to be fair, it's a domestic.
Yeah,
it wasn't criminal. Okay. I'm remembering a domestic.
An elected official here.
No, it was a domestic case well before I ever came to the DA's office.
No, not me at all.
Fair enough. if we had, if that was true, then I had to disclose it for the record.
Okay, no, not.
That's the only reason. All right. So secondly, number one, I appreciate you coming up and I take to heart what you're saying, that you take your name serious and you don't just throw it around.
No.
Right? Your reputation is something to be valued, and I appreciate it. When you talk about Mr. Joubert, your dealings with him is church, right?
Mm-hmm.
Just
church and stop the violence.
Okay. And you just like, since Tommy Coleman's the only prosecutor in the courtroom right now, he and I know each other professionally. We work together, right? And I have my opinions about him. We see each other in work, just like I have friends in church. I see them in church. If I go to the gym, I've got friends at the gym, right? And we develop opinions based upon what we see during the time in which we see them, right? And based upon what you've seen, that's what you're giving the judge here today, right?
Yes, sir.
Today, did you learn about the indecent exposures?
Today was my first time learning about that. Yes, sir.
Right. It's not something shared in church,
no.
Right? Were you aware that he went to TYC?
Yes, I was aware that he went to TYC.
Did you know that
he's been in and out?
He's been in and out of trouble. You've known that.
Yes, sir.
Right? Did you know what he went to TYC for?
No, I know he's been in and out of trouble a lot. I don't know the specifics of every time he's been.
Did you know that he was placed on probation for robbery?
Yes, sir. I did know that.
You know that was revoked.
Yes, sir.
And he went to prison for that.
Yes, sir.
And it was within a year that he picks up these charges that placed him on probation.
Yes, sir.
And it's within a year after getting this probation that he picks up a new charge.
Yes, sir.
And yet you still have all that opinion.
Yes, sir. I still feel good about this young man.
Is there anything you could have done to prevent him from driving with it while intoxicated with a child in the car?
There's nothing I could have done. No, sir. I don't think there's nothing nobody could have done.
So are you aware that the lady that was the passenger in the car that day tried to talk him into letting her drive?
No, sir. I wasn't aware.
Do you think you could have talked him out of driving that day? Maybe you could have drove instead?
I definitely think I could have.
What greater ability do you have versus the lady he chose to spend the night with, who happens to be the mother of that child?
Men, and let me explain this to you when I say men, like a father figure. I know if I can look at a young man and I can convince a young man to do something, I also know I have the physical strength, if necessary, to stop a man.
I'm smiling because I understand where you're coming from.
Yes, sir.
If he wouldn't have listened to you, you would have made him.
Yes.
That's what you're telling me.
Yes.
Right. You willing to sign up for that for however long he's on probation?
Am I willing to sign up for what, sir?
Be there physically to make sure he does what he's supposed to.
Yes, I will be there physically for him.
All right. No further questions.
Anything else?
Nothing, brother.
All right. Thank you.
No problem. Thank you.
Anything else to add by the parties?
Yes, sir. We have what we call Gary Senegal.
Come forward, sir. And please raise your right hand. You solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Go ahead.
Please state your name for server of the record.
Gary Senegal.
And Mr. Senegal, could you?
Is it Senegal or Senegal?
Senegal.
Gar, yeah.
AUR,
Yes. And what do you do for a living, sir?
I don't do a lot. President Stop the Violence, father for grandfather, part-time in Rogers, truck driver, ex-correction officer, activist.
Could you explain to the court what is your involvement with this young man that we have here?
I met him while I was at the jail, and I watched him. I watched him change, and he actually got better. You know, as I saw him, and after he got out, he was a trustee. He came in as he was a regular inmate. Then I was known around the jail for talking to the guys, talking to some certain young men, you know, and I watched him. He actually changed, listened to me. Had to pop him a couple of times, but he listened.
And the information that you've been sitting in the audience and the information that you've been hearing about what he's doing now in the construction company and several things that in this nonprofit organization stuff. You've heard all of that, is that correct?
Yes, yes.
All right. Of course, the issue before the court is whether to put him in the penitentiary or to place him on probation. The man that you know that he is met, you feel comfortable making a recommendation that that the judge could allow him to be on probation, extended probation, and that we would not see this young man again before this court.
I stand on it because I listen to everything that he says that happened. I know about a lot of it, but I just post if God will allow some of our past transgressions to be read out loud, it would sound worse than that. You know, everybody in this room, yeah, hidden stuff. You know, it's just exposed, and it's not to make light of it. But like Albert said, a lot of these young guys, young black men, young men, they need the father figures. A lot of them don't have it. And it's not to condone it or to make excuses of it, but that's why I'm here. You know, I feel like I feel it. You know, I have sons as well, you know, and sometimes they slip through the cracks, you know, but does that mean he's jailed or jailbird? Is he a convict? Is he an inmate? No, he's not. I've been in the profession. I've been in that business for a long time. And if I don't BS, I don't like to waste people's time. Time is money and it's his time. If he wasn't that person, I wouldn't be standing right here. I would say, yeah, he belongs in jail. Jail is what's going to rehabilitate him. But he's not, that's not the character that I see. And that's what it is.
I don't have any questions for you, but I know you and I've talked on the phone before. I remember before you started the Stop the Violence.
Yes.
But I 100% appreciate everything you're doing for our community. So but the good work.
Yes.
The judge will remember you testified last week. So you're making a habit out of this. When we're going to see you on next week. All right. Thanks, sir.
Last witness is Todd Broussard.
And please raise your right hand. Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Please lower your hand, sir.
And for the record, sir, please state your name.
William Todd Broussard.
And Mr. Broussard, what do you do for a living?
A lot of things. Entrepreneur.
Okay.
Sales manager for Tees to Your Door. I run a nonprofit called the Mentorship. And I do Airbnb businesses. So that's what things is.
Could you explain to the court what's your involvement with the young man that we have before the court, Mr. Jupiter?
My knowing Devontae stretches back to, I started substitute teaching in the district in 2010. I was working for Channel 4 before that as the media manager. Corporate did layoffs, so I resorted to the school. As I was in the schools, I met the young man in middle school. I'm going to say 2011 or so. He was a fighter. Yeah. He would get into it with kids at school, and I tell him, I said, you know, if you like to fight, you might need to go and get paid for it. You know, turn that into a business or structure any of that anger. We take it and push it towards something positive. Little did I know, later Miss Regina Rogers would take me down to Benny Rogers, and
I saw Tepe there. That was my first visit. It was an eye-opening situation. So I'm like, man, I see so much potential. At that moment, I knew, and I'm gonna say at that moment, when we were in school, I saw the potential. So when I was brought there for that moment, I saw him, I gave him some very words. He lit up, lit up. Now, did he have his doubts? Was I there all the years? Well, we were back and forth. Of course, he served his time. But when he came back, I've never seen like this before. Never in my life have I seen him to his stature of a man before. I can honestly say if, for one, the accountability, the upfront taking responsibility for his actions, first and foremost. I truly believe that if he was where he is today, he might have fought this case and possibly won. Financially wise, let me say that. I also believe that because of his truthfulness and taking accountability, he told me that then. I asked him, please don't sign for a 10-year deal. I asked him personally, especially it not being deferred. But he said, man, I'm going to do it. But he was also, again, frightened.
That was on the probation.
That was on the probation that he took. That was my first time in kind of staying. But I will say this, and I will say this to you and your honor. Mr. Hammond and I had a conversation after he got the DWI. And he specifically told me I have him in my crosshairs. And took that to us. Took that as in, okay, I see crosshairs as in a scope, hunting, or I could understand coming from him being a prosecutor that, oh, I'm going to get him. So my request, and from what I see now, that this young man, regardless of what he has been through, regardless of the decisions he has made, I seriously doubt that we will see him again.
So the issue before the court is whether to put him in the penitentiary or to allow him to remain on probation. Listen, the man that you know now, the way he is now, do you think he is worthy of being given a second chance and being continued on and being placed on probation?
Yes, sir. I do believe that he should be in probation. I will also say this to Mr. Ham. The other conversation we had was about Paul, who also wrote Romans in the Bible, saying Paul went to prison. I get it. I understand. But he also wrote Romans 8:34. If God be for us, who can be against us? So,
is there anything else that you think you need to tell the judge that would be helpful in the issue before the court?
Thank
you. Brother, this with us.
All right. So, no offense to the other three gentlemen that have been character witnesses. You've been with him the longest.
Yes, sir.
And the reality is that every time he's come to court, you've been here.
Recent.
All through this current situation, we've seen you every time.
Recently.
That's why we've had conversations.
I wasn't there
before he went to prison. So that's right.
But you were here when he took the probation deal.
Yes, sir.
And had anybody asked you and placed you under oath, that same day you would have said same stuff you said today, which is we're never going to see him again. He's never going to commit another offense. In fact, you told me that day.
Did I tell you that?
Yes, sir.
You sure?
Pretty sure.
No, sir.
Okay.
No, sir.
You're under oath. We'll go with your answer.
Yes, sir.
You don't remember us saying that.
I spoke to you about, I said, if he is taken in our custody, and I
Yes,
said
sir.
custody, I'm sorry. If he's taken under our
Tutelage, your program. Yes, sir.
We're gonna mold him.
Yes, sir.
We're gonna mold him.
Did you do that?
Yes, I
And
believe
was that before this new offense?
that was the beginning.
Right.
Yes, sir.
But this happened anyway,
Yes, sir.
right?
Yes, sir. Man falls 7 times. You back up.
Yes, sir.
Yes, sir.
As I said,
By the way.
as I said, the pastor, there's only been one perfect man that's walked this.
Yes, sir. Yes, sir.
It's not any of us in this courtroom.
Yes, sir.
All right, thanks, sir.
Anything else?
Nothing about this witness.
Thank you, sir.
I would like to ask my client, is there anything before we submit this to the court? Is there anything else that you would like to tell the court in closing?
Yes. So all three of y'all, I understand that. I'm done. You say, I know you say you heard it, this and that. Y'all not gonna see anything.
Anything else?
That's it.
That's all we have to.
I have no questions of him, Judge.
What are y'all asking for? Stay.
Sir.
What are you asking?
I'm going to respond. I'm going to let him start.
Go ahead, Bruce.
General, the new case of DWI, we're asking that he was given probation and that it run concurrent with the court allowing him for the court to extend his probation term on this evading detention, not revoke his probation and allow him to continue under whatever terms the court deems appropriate to remain on probation. And that's what we're seeking.
My opinion hasn't changed, Judge. I appreciate and I love and respect the gentleman that have showed up for your behalf today, Mr. Judah. The harsh reality is that the original incident that got him started down this path that you're making this decision today on, those misdemeanors are just horrible. And Lamar was doing everything they could to try to find who was involved in that. And what I've witnessed today is the same thing that's continually occurred. It's a man who accepts responsibility in quotes, but offers so many different explanations and reasons why it's not as horrible as it sounds. But the reality is, it is as horrible as it sounds. He was wagging his genitalia at 2 different college girls in Lamar in 2022, less than a year after getting out of prison. We did not teach him a lesson on good charactered men. I did not hold his feet to the fire. I did not seek his time in prison whenever he was up on the trial docket on this evading detention with a motor vehicle. And it is not like he keeps trying to tell the court. I remember the evidence. I know what the witnesses would have testified in the trial. There was a high rate speed where he did disregard stop signs. He put people at risk. It was a clean and clear evading. Yet he started probation. And not even 8 months later, he's in a vehicle, drunk twice the limit, with a lady who tried to talk him out of driving because she was worried about her child. We're lucky that we're not here on some kind of manslaughter charge, which Your Honor seen too many of. I can't, in good confidence, in representing the county, recommend anything other than an 8-year sentence on the underlying charge, which is the evading. And I leave it to Your Honor's discretion as to what should be done on the DWI.
Anything else?
Mr. Ham is putting great emphasis on those misdemeanors that occurred prior to he being placed on probation for this evading. And my client has taken, just a probable cause affidavit does not prove the allegations that Mr. Ham is trying to convince the court that is true. And he is in fact under oath denied some of the allegations, some of the statements that are contained in the probable cause affidavit. It appears to me that the state is wanting this court to revoke his probation and punish him for the allegations that are stated in those probable cause affidavits, then I would submit to the court that is not the issue before him. He's been proven that he is a businessman. He's done work for the Antioch Church, of all things, and he's smack dab in the middle of being highly involved in a nonprofit organization called Stop the Violence. He's just simply not the same man that he's had in the past. He has been truthful with the court. He has taken responsibility. And this is a young man who I feel, if the court would give him the chance, that he would be successful on probation. You would not see him before. Yeah.
All right. Let me get I need some clarification.
Yes, sir.
The robbery conviction earlier, he was convicted. Was that 10 years regular probation in 2019?
Yes.
And was it revoked?
Yes.
And you were sentenced to what? 4 years. All right.
Here's the packet of information, Judge.
Okay, thanks.
Yes, sir.
All right. The evidence is before the court. The court has reviewed the court's file and listened to the evidence presented in the arguments of counsel and also the statement made by the defendant. In this first case, this motion to revoke probation in 23 CR 168. Okay, there's some changes that need to be made on the paperwork y'all fixed. Number one, it said prosecution will proceed only on counts 1, 2, and 3. He pleaded to 1 and 2.
Yes, sir.
All right, so I'm going to correct that. And the agreement by the parties that the agreement is that whatever sentence in the disposition of this case is going to run concurrently with 156, that the defendant is going to be entering a plea of guilty to the state jail felony of driving while intoxicated, which was based upon the allegation in the motion to revoke probation, allegation number 1 out of the 2, the defendant pleading true to driving while intoxicated with a child passenger and also being at a location other than his residence after he was on his curfew order. Correct?
That's correct.
Okay. So this is so there is some conditions based upon an agreement in this case.
Yes, sir.
All right. So if I follow this agreement, he has no right of appeal, but y'all mark through that, right? If I follow it, he's going to, okay, y'all mark through this, which is.
On the concurrent, yes, sir.
But I'm going to change that.
Yes.
He has no right of appeal if I follow this, right?
That's correct.
Okay. It's reflecting otherwise, then we're going to fix this. There we go. Don't need to fill in at the bottom of that, but the defendant and gotta get it right. Okay, on this, Mr. Ham, the notice of intent to destroy evidence, generally that's signed by the parties as well. Y'all just mark through it as.
That's because that's on the motion, Judge. That was originally signed, so that document would, that would be fine. I don't think we need to duplicate it.
And then the agreement on this new indictment, the state jail felony, again, this is unagreed, right?
Correct.
And it's what are we doing? Whatever the court does, are y'all waiving right of appeal or anything like that?
Yes, Your Honor. That's why it's, we've got a signed deal that whatever you decide, we'll agree to run it concurrent. So if you do probation, we'll agree that those terms run concurrent. If you do prison and state jail time, we'll agree that that time runs concurrent. It's all a part of him accepting the responsibility today.
Bill Alves. What? There's nothing further to add. Let's take these up in numerical sequence. We have 23 CR 168, the motion to revoke probation in the defendant's case, and the court is going to make the following findings after listening to the evidence presented and the arguments of counsel. That again, the defendant was placed on regular probation as he entered his guilty plea for the third-degree felony of evading arrest or detention with a motor vehicle on January 28th, 2025. He was mentally competent to enter his guilty plea at that time. There was sufficient evidence supporting his guilty plea to find him guilty beyond a reasonable doubt. And the court found the defendant guilty beyond a reasonable doubt based upon the plea agreement that was reached. The defendant was sentenced to 10 years in prison, and that was suspended. He was placed on regular probation for 10 years. In today's hearing, the defendant admitted violating the terms of conditions of probation by committing the offense of operating a motor vehicle while intoxicated with a child passenger under 15 years of age on or about August 30th, 2025, which would have been 7 or 8 months into his probation. And also, he pleaded true to being at a location other than his residence at approximately 1:08 a.m. on or about August 30th, 2025. Each of these allegations, 1 and 2, are violations of his probation order, as he was required to abstain from committing any offense against the laws of the state or any other state or the United States. And also, he was required to be inside his home every day between 10 p.m. and 6 a.m. The court finds that there is sufficient evidence supporting this motion to grant it by preponderance of the evidence or greater. The defendant pleaded true to these allegations voluntarily, knowingly, intelligently. That is enough to grant this motion by preponderance of the evidence or greater. It is so granted. Your probation is hereby revoked, and you are facing no less than 2 nor more than 10 years confinement in prison. And from the evidence presented, the court finds that it is in the best interests of justice to assess your punishment at confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. You have served about half a year. You will be given credit for all that time you have served. This sentence shall run concurrently with what is about to happen here in this 26 CR 156. In this case, the court finds that the defendant under this case, you were charged with this indictment on or about August 30th, 2025, committing the state jail felony of operating a motor vehicle while intoxicated with a child passenger. And you are pleading guilty to that, sir, today, correct?
Yes, sir.
You were doing this voluntarily, knowingly, intelligently, based upon discussions with your attorney. And there is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. As State's Exhibit 1, which is admitted into this hearing, states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. In this case, you are facing no less than 180 days up to 2 years in the state jail. I find the evidence submitted sufficient to find you guilty beyond a reasonable doubt. I hereby find you guilty beyond a reasonable doubt of this offense. You were hereby sentenced to confinement in the state jail for a term of 2 years. And listen closely, that's going to be suspended. You will be placed on regular probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Most importantly, we're going to focus on some of the issues that we've addressed that you have kind of fought with in your composure, and we will help you. We want you to get across the finish line. These sentences are going to run concurrently with each other, by the way. So what happens is you have a few months, maybe, or less to complete the service of this sentence of 2 years that the court assessed on this case that you were on probation for. And again, we can't take lightly the major reason that you are revoked is because you had, my God, a child in the car. And it is a felony to operate a motor vehicle with a child passenger. We can't ignore that. It has its consequences. It's a felony. You got 2 felony convictions. You've had 2 felony convictions even before today. You got to be careful. Those 2 felony convictions, a third felony above a state jail felony, you're looking at 25 to life. You know, so for yourself and for the betterment and well-being of your family that you profess that you love, which I think you do. You put the child in harm's way, and that you have to be held accountable for. And these are all issues that are fixable. Plus, you are surrounding yourself with people who are role models and great examples. Failure is not an option for you, especially with your surrounding with all this support. The court finds that under these circumstances, that a 2-year sentence in this case, which is the lowest that can be given, is appropriate under the circumstances and under the changes that you have made in your personal life in commitment toward responsible behavior. But once again, it's a felony offense that you committed, and a child was in harm's way, plus others, and that has to have its own accountability. Okay, the court finds that these 2 sets of judgments are in the best interest of justice and are fair based upon what this court has heard and the evidence presented. And in this other case, this one, the second one that was unagreed, you have a right to appeal that. It wasn't an agreed decision unless you waive rights of appeal, and we will talk about that. There will be on the conditions of probation on Mr. Jobert's case here, on this second case that we're putting him on probation for, state jail felony. Make sure we target the issues that were addressed today on drinking and the moral reclamation therapy is a great program which helps defendants understand and appreciate decisions that they're about to make and the consequences. And it really helps folks change their method of reacting too quickly and making mistakes versus composing yourself when a decision has to be made, especially under stress, and methodically thinking through the decision for the right choice. And the moral reclamation therapy, MRT, we call it, really works great for people. And it's a program that you can use the rest of your life to be a better person. Anything else?
Can I ask one question?
Yes, I had a whole lot of the time.
We heard my client saying that while he was in the penitentiary on that 4 years.
No, after the 4 years, and I got out on parole. Parole broke my parole.
You were on parole.
Yeah, they were both because of the indecent exposure, but they had to use the exposure in the detention.
You have to be in a penitentiary and have a detention.
Yeah, hold on, they can't pick me up for the detention.
While you were after they revoked your parole. Okay, so what he's saying is that there is additional credit Uh,
I don't know what it is, but
I'll get with the clerk.
but yeah,
We'll get this.
coordinator works with TDC on that, and they will make a determination of how much it is, and if there's a challenge to it, let me know. But
Yes,
I've been doing this 19 and a half years, and all challenges have been proven wrong.
Yes.
In 19, they're pretty good at what they do on determining how much credit. But I don't know what they're going to do on this new case, because you're creditable in a quarter of your time, and he served almost half. So
we'll check with
it's
TDC.
maybe one of those where he goes in and out.
We'll check with TDC, make sure he gets proper credit.
But anything else to add on this?
Okay.
All right. All right. Right now, he's going to be taken into custody for the sentence. Do you need to take care of getting private things with making sure that folks get what you're? No findings. Terms and conditions which are normal and customary for DWI cases. Where is that on this? Langston? Great. Thanks. Here's Mr. Joe.
The state would rather, reflection.